Before the court is filed 23110 FC, People of the State of Michigan versus Shanda Vander Ark. It's a continuation of the trial. After the afternoon break, the jury is secure in the jury room. Mr. Johnson, before we proceed, I just want to inquire in terms of your client is not present in the courtroom. Can you give us an update from your perspective on her?
The situation remains as it was, Your Honor. My client desires not to attend further.
Okay. Have the people had a chance to review the proposed jury instructions and verdict form?
Yes, Your Honor.
And any additions or corrections to those?
No, I believe they are satisfactory at this time.
All right, Mr. Johnson, have you had an opportunity to review the proposed jury instructions and the proposed jury form?
I have.
And, or excuse me, I should say verdict form, and any additions or corrections you have?
Thank you, Your Honor.
All right, well, it's my intention after closings to go right into closing instructions. Any objection to that, Mr. Roberts?
No.
Mr. Johnson?
None.
All right, let's go ahead and bring him out. Mr. Weaver, please rise.
I know.
All right, you may be seated. All right, welcome back, ladies and gentlemen. We'll commence with closing arguments. Mr. Roberts.
Good afternoon, ladies and gentlemen. Once again, on behalf of the people of the state of Michigan, I want to thank you for your time and attention to these matters. As we've repeatedly indicated, and as now you've seen through the evidence and the testimony in this case, these are incredibly difficult, incredibly sensitive matters, and we certainly do thank you for your time and attention to them. I usually like to start closing statements in a homicide trial such as this by showing you a photograph. And that photograph is usually the victim in the case prior to their death. In this case, our victim was a child. Would hope to be able to show you a photograph of what he looked like within a few months of his death. I can't do that. I can't do that because the defendant apparently took it upon herself to make sure there were no photographs taken of the victim in the 6 months leading up to his death. In opening statement, I told you about that song, What's the Matter Here? And the line from that song, answer me and take your time. What could be the awful crime he could do at so young an age? So ask yourselves that. What was the awful crime that Timothy committed to have these atrocities perpetrated upon him? What did he do? He stole some food? He took some things apart? That's all I heard. And he paid for that with his life. Like I told you, I can't answer the why. I can't answer why the cold and lowly things were done to him, because it doesn't make sense. It does not make any sense that a 15-year-old should be made to suffer the way Timothy was, to be made a prisoner the way Timothy was. And make no mistake, he was a prisoner in that home. We give prisoners rights. Prisoners of war have rights. Timothy had none of those because the person charged with his care and custody refused them, kept him locked up in the basement of that home with motion sensors and alarms to make sure he didn't even go upstairs, let alone anywhere else. But not to even go upstairs. Alarms on his body to go off. He didn't like the noise. motion sensors on the stairs if he tried to go upstairs, alarms on his small room, closet, door if he tried to get out, motion sensors if he put his arm down during a punishment, cameras watching every moment. And at the heart of all of this, the defendant. That alone, ladies and gentlemen, is a basis for first-degree child abuse. The serious mental infliction of harm upon Timothy as a result of her actions is all you need to find that the defendant is guilty of first-degree child abuse. And that's the tip of the iceberg. Towards the end of Ms. Vander Ark's testimony yesterday, I kept pressing her on that question. What did he do? What is it that he was doing? Apparently so desperate for food that he ate frozen chicken nuggets and uncooked hamburger. Explain this to the jury so they can understand, so they can make sense of why it was that you chose to do these things to him. She got mad at the end, towards the end of her testimony. It became clear that she was still mad at Timothy. He was sneaky and deceitful. Over and over again, he was sneaky and deceitful. He'd sneak things when he wasn't supposed to. He was deceitful. He would lie about things. And you heard over and over again in the text messages. He's lying about that. He's not going to get away with it. This is all fake. All of those things. So ask yourself this question. Who do we know was sneaky and deceitful here? The defendant. And it started when, after 18 minutes of her son being unresponsive and so obviously deceased, she finally decides to call 911. But she better get her story straight before we call 911. So what's the last thing she says before she calls 911 to Paul? We'll have to tell him he's been on a hunger strike. Before that, where's your belt? Put your belt on him. I want to make it look like he's been this way. No emotion in her voice, no tears. Start with, why does it take you 18 minutes to call 911? You saw the image? You saw Timothy laying there on the floor? You heard them repeatedly talking about how he was stiff, how he wasn't moving, how he wasn't breathing, how his eyes were fixed open, and they don't call 911. Who does that? How does a parent do that? Paul asks her, should we call 911? Should we call for an ambulance? Not yet. It's almost another 10 minutes before she calls after that. Then when she calls 911, the lies start. I came to check on him at 5:30. And then when I came down, he was unresponsive on his bed. Both completely false. We know he wasn't checked on at 5:30. We know the last thing that she did and said to her son. You could hear it in Lieutenant Hooksman's testimony today. The last thing she did to her son was to drag him into a small room, throw him down on the ground like he was a piece of meat on a tarp in the room where she says he wanted to be. That was his comfort. Positions him in front of the camera so she can see. Calls him stupid. And when he has the indignity to roll over, no, that's not good enough. She comes back. Positions him again in front of the camera. Makes the dog lick his face to get a reaction from him. Holds his mouth closed and said, see, dummy, you don't need to open your mouth to breathe. Imagine those being the last words you said to your child. Because that's what it was. That's the last thing anybody said to Timothy. You don't need to open your mouth to breathe, dummy. Shut away in isolation after months and months of physical and mental abuse at the hands of the defendant. and Timothy slipped away. No, I went to check on him at 5:30. Lie. I have to put you on hold because I have to pull him off the bed. Lie. He's been on a hunger strike for the last couple of weeks, but I was just about to call a doctor. Lie. Then the lies continue. Officer Peasky, Detective Peasky, interviewing the defendant. Why is there a lock on the fridge and the freezer? He's got access. The locks are on the fridge and the freezer because he would leave the door open, but he has access to the pantry. Lie. Text messages over and over again talking about how he was able to get into the pantry and her repeated commands to Paul, starting in February, to make sure that all the food is locked up and Timothy doesn't have access, including the pantry. Yesterday on the stand, that shifts into, well, he did have access to a small cabinet where there were some canned goods. So this boy who was dying of emaciation, we're supposed to believe that he's going to have the ability to go into a cabinet to get canned goods, get a can opener, open them, and cook himself some food. Well, we know that's not true. He's not allowed to have food. He can't do that. The only thing you can hear in these text messages that he's allowed to have for those last few weeks after the June 13th photograph, which we'll get to in a minute, is the bread with hot sauce. Did you hear any testimony from her about full meals that she would cook for him? Anything? No. What's her response when she gets sent the picture? Mama, we need to actually feed him. That's the phrase. We need to actually feed him? He's bone thin, Mama. I think honestly, we need to actually feed him. And what's her response? Give him bread. Give him bread with peanut butter. The unresponsiveness is probably fake, but I see what you mean. Yesterday, she wants you to believe, I didn't see that photograph. She literally uses the word see in her text message. I see what you mean. And then tries to split hairs about what that phrase means. Let's assume she didn't see the photograph for just a moment. Your child is so alarmed that he's saying he's bone thin, I think we actually need to feed him, and your first response is give him bread? What does that tell you about her mindset? Her mindset is, that's what he gets to eat. He gets bread. Maybe some peanut butter. That's what he gets to eat. Not the canned goods that he can get access to under the cabinet, and heaven forbid he commit the crime of sneaking a piece of candy or eating some frozen chicken nuggets. Give him bread. Detective Peasky. Well, after the stroke, he went on a hunger strike. That was a lie. Paul told you it was a lie. He never went on a hunger strike. There isn't a single reference here to him being on a hunger strike in January or in July. The bigger binder. More of the text messages, just about Timothy. All of the text messages, just about Timothy. I gave her the option yesterday. I said, show me the text about the hunger strike. You're so concerned about everything. You're so concerned about watching the cameras, setting the alarms, making sure the food is what it's supposed to be, making sure he's running stairs, doing wall sits, getting cold baths, all of that stuff. Show me in here where you're talking about him being on a hunger strike. Nothing. The hunger strike thing isn't real. And think about it for just a moment. If your child was on a hunger strike, what would you do? I know what I'd do. Remember, we talked about reason and common sense. What's the reasonable thing to do? Get your child to a doctor. Get your child to a therapist. Get your child to something. But what does she actually do? The first set of text messages we hear? The first text message, February 18th. So this would be on or about the time of that first hunger strike. First, rude, and second, why are his hands free? Ooh. That's where we're starting. Why are his hands free? Because he's a human being. And what did he get into that he felt he needed to brush his teeth to hide it? I think most parents would be ecstatic about their child actually brushing their teeth. I know I am, and my kids do it. But to her, him brushing his teeth is a sign that he's hiding something. Sorry, didn't know he was up. What do you mean you didn't know he was up? Has he not been upstairs against the wall? So he's supposed to be against the wall. No. What? Why the heck not? What the heck has been going on? Check the brownies in the kitchen. Check everything not locked away. Check where the flipping keys have been. This is in February. We're not even talking about the last couple of weeks that Timothy's alive. This is in February. And she's already started talking about locking away food. 5 months before Timothy dies, and she's talking about restricting his access to food. Hunger strike? No. She realized late last night that he was thin. She threatened to take him to the ER if he didn't eat. We know what she did to him the last night. She wasn't remotely concerned about his physical appearance. And make no mistake, she could see his physical appearance, because she dragged him into the closet, and Lieutenant Hooksman described to you in unfortunately vivid detail. And the images are horrifying, truly horrifying. But you've seen the photos of what he looked like when he died. And that was hours before. A mother dragging her child into a room, throwing him down on the ground. Does that sound like I realized last night he was ill, and I threatened to take him to the ER if he didn't eat? So I made him a piece of toast with butter on it? She even admitted that was a lie. Said he was done after he ate the toast, went downstairs. He couldn't even move at that point. You heard Dr. DeYoung's testimony about what happens to the body as it breaks down, as it goes through these stages of malnutrition. He was 69 pounds. The average, and he was average height, the average 15-year-old male is 132 pounds. He was 62 pounds underweight. And we saw what he was like 3 weeks before. Make no mistake, she saw what he was like 3 weeks before. She got ready for work in the morning and went to check on him. No, that's not true. But it's interesting that she mentions getting ready for work, because on that video you can hear her. And she's been working on Timothy for a number of minutes at this point in time. And she says, well, I guess I'm going to be late for work, but we've got to get him responsive. Talk about cold. I guess I'm going to be late for work. Your child is dead, and all you can think about is being late for work? She had to have Paul help him get off the bed. Lie. On a hunger strike 2 weeks ago. Lie. There are no pictures of Timothy since January. That one's true. And then when the detective starts to ask about the unusual things in the house, what leg shackles? What are these leg shackles for? Oh, those are Paul's leg shackles. Now bear in mind, this is hours after this has taken place. And it's just lie after lie after lie. Well, how do we know it's a lie? May 18th, the Wisely transaction is handcuffs and leg cuffs for Timothy from Amazon. Figured it would be okay to get those right away so we can talk about the sensors and stuff. That's her text message. The handcuffs and leg cuffs for Timothy. Well, I would never use them on Timothy. June 27th. He's moved around, so he got the cuffs in front of him instead of behind him. So he's handcuffed behind his back. I put the cuffs back behind him. Her. I put the cuffs back behind him. I will have to deal with less than 2 hours of sleep today, but not letting him get away with this BS. June 27th. That's 2 weeks after the photograph goes to her, showing how thin he is, and he's handcuffed behind his back by her. Could this be any more about her? Could this text message show you any more how this was all about her, I will have to deal with less than 2 hours of sleep today, but not letting him get away with this BS. It's all about her. Fell out of bed at 5:30. Nope, never happened. Never went to check on him. The last thing you said to your child was, "You don't have to breathe with your mouth open, dummy." Oh, there's alarms on that room down there because we had the sewing stuff in there. Lie. The cameras were in the home because Gabriel would strip down naked and wander around. Maybe a camera was in there for that. But she doesn't care about wandering around naked. You heard the text messages. Timothy had to clean the garage with nothing on below his waist and then stand against the wall with nothing on below his waist. He had to earn his right to get clothes back. She doesn't care if her kids are running around the house naked. It's a form of punishment for her. Doesn't restrict his movement with shackles. Another lie. Now, Ms. Vander Ark was up here yesterday for quite some time, and she told you about what an intelligent lady she is, and I will give her that credit. She is a highly, highly intelligent lady. It takes a lot to finish second in your class in law school, graduate magna cum laude. It takes a lot to get a score of 182 and pass the bar exam. Heck, it takes a lot to just pass the bar exam, let alone get a score of 182. So this is a highly intelligent woman we're dealing with. She clerked for not one, but 2 different judges, was clerking for a judge at the time her child died. She wants you to believe that she doesn't remember any of this. Can't remember any of these things. I don't remember that text message. I don't remember doing that. I don't remember saying that. Every time she's confronted with something that she did or something that she directed to be done to Timothy, she can't remember. How does this woman hold down a job as a legal clerk? If your memory problems are that bad that you can't send these text messages, how are you not seeing a therapist? How are you not on medication to address these issues? You couldn't hold down a job if you were that, let alone a job as a legal clerk, if you had that many memory problems. Let's talk about the things that she can remember. Oh, right after Mother's Day, he weighed 104 pounds. And I asked a couple times, 108 pounds? No, 104 pounds. She's absolutely certain about that. Somehow she can remember 2 months before Timothy dies, what he weighed. That's a detail that she can remember. The bad things? No, can't remember any of that. That's the detail that she can remember. How self-serving is that? That you can only remember the good things and you can't remember the bad things. And 3 weeks later, that's how he looks. Does that look like 104 pounds? Sure doesn't look like it to me. There isn't a single text message in here or in there, the larger binder, where she says, what are we doing? I don't understand why we're doing these things. Why are these things happening? Why is Timothy on a camera? Why is Timothy in handcuffs? Why is Timothy locked away in a small room? If she has all these memory issues, where are those text messages? Where are the memory issues in here? She knows everything that she wants to have done, and she's telling Paul day after day after day what to do to Timothy. Not struggling to remember what it is, not struggling to remember what it is that Timothy had done to be punished in this way. Not struggling with any of that. She doesn't have memory problems. She might have chosen at this point to block those things out from her memory. But make no mistake, all of these things happened. She did all of these things. It's only now that suddenly she has memory issues. so stressed out, so much stuff going on. Not so much stuff going on that you can't spend half of your time at work, especially in those last couple of days, just watching the camera. Watching while Timothy's in the bathtub for hours on end the day before he dies. Telling Paul to pour more cold water on him. Telling Paul to take a pizza roll. Take a pizza roll, warm it up, hold it in front of his face and see if he reacts, but be ready to snatch it away if he tries to eat it. This is supposedly when he's on a hunger strike. And you're going to bait him with food? She did all of these horrible, horrible things. And she doesn't get to hide behind saying, I just don't remember doing them. Or, I didn't intend for Timothy to come to any harm. Of course she intended for Timothy to come to harm. Of course she did, ladies and gentlemen. No rational person, no person who can score 182 on the bar exam, let alone any other individual, no parent, nobody with the logic and reasoning skills that she has could not understand the consequences of what she was doing. I didn't intend for any of this to happen. We don't even know if that's true. It's not. But we couldn't even say that that was true anyway. She can barely even say that because by her account, she doesn't remember doing any of these things. For all we know, she did intend for all of these things to happen, which of course she did. And remember we talked about the cookbook in voir dire. Went over it a couple of times. Unless you hear a defense from the judge in these instructions that says, if you find that the defendant just doesn't remember these things, that she can be found not guilty, she doesn't get the benefit of that. Don't add to the cookbook. Don't give her a defense that I just don't remember doing these things. I hope on some level, maybe she doesn't remember these things because they are so cold. They are so lowly. They are so dangerous that they took Timothy's life. Sleep deprivation. No clothes. Hot sauce. You heard the description of the hot sauce today. Oh no, that was Paul's idea. The hot sauce was Paul's idea. Paul's text to her. July 2nd, 3 days before Timothy dies. So apparently this hot sauce isn't just Carolina Reaper, it's also Trinidad Scorpion Chili Pepper. Her response? Yep. She knew what it was. She went out of her way, whether it was her or whether it was Paul at her direction, or the two of them doing it together, out of her way to find a hot sauce that would be too much for him to take. Let's set aside the logic for just a moment that how is it that you decide you're going to punish a child with hot sauce if the child likes hot sauce? It's ridiculous. That's the form of punishment? Of course not. That doesn't make any sense. Again, common sense. Don't check it at the door. He didn't like hot sauce. You know he didn't like hot sauce because they wouldn't be using it for a punishment if he liked it. This is July 2nd. This is weeks after this photograph is taken and sent to her when she can see how thin he is. Hot sauce. Hot sauce on bread. 4 slices with hot sauce. 4 slices, as long as there's plenty of hot sauce on it. Then if he waits 30 minutes, he can have some without hot sauce. So his reward for eating 4 slices of bread with hot sauce on it is if he can wait 30 minutes, he can have 4 regular pieces of bread. 30 seconds after she sends that text, she talks about getting chicken nuggets and fries for G. She can process all of this in her head. Whoop, punishment, hot sauce, Timothy, whoop, fries, chicken nuggets for G. That doesn't sound like somebody who doesn't know what they're doing. That doesn't sound like somebody who has memory issues. That doesn't sound like somebody who's not in control of their actions. She's in control of everything. She is watching everything. She knows everything. Even when Paul is supposed to be watching. she's watching as well and critiquing how well Paul is doing watching. He's with Timothy at the tub, and she's watching to make sure that Timothy doesn't look too comfortable in the tub. Move his head. Looks like he's trying to get comfortable. Pour some cold water on him. Do the pizza roll thing. Somehow, as an act of grace, mercy, whatever you want to call it, go ahead and give him 2 pizza rolls, and I don't care if they're frozen. It's difficult to understand how a person can be so detached to another person, let alone a child. Ladies and gentlemen, it's the people's position in this case that the defendant is guilty of 2 crimes. That first crime is first-degree child abuse. In order to prove the crime of first-degree child abuse, I do have to prove the following. First, that Shanda Vander Ark is the parent of Timothy Ferguson. That goes obviously without question. Second, that the defendant either knowingly or intentionally caused serious harm and or serious mental harm to Timothy Ferguson. By serious physical harm, I mean any physical injury to a child that seriously impairs the child's health or physical well-being, including but not limited to brain damage, skull, bone fracture, subdural hematoma, subdural hemorrhage, dislocation, sprain, ankle, internal injury, poisoning, burn, scald, or severe cut. She killed him. She starved him to death. She directed that he be in an ice bath for hours at a time. And what was her story yesterday about the ice bath? Well, they didn't start off as ice baths. Okay, so they started off with cold water. No, they started off with hot water. Well, why would you put ice cubes in a hot bath? And how is that a punishment? Then confronted with the text, again, don't remember. Let him know that if he tries to sleep at all, sleep deprivation, he'll get another ice bath, there's been one before, sometime before you leave for work, and another when I get home. That's the description about 3 ice baths in one text message. I said, you wouldn't make up additional ice and put it in the freezer, would you, because you needed it for later? No, we wouldn't do that. Might want to toss the ice that is made into some Ziploc bags in the freezer tomorrow, or if we need a bunch more. You heard Dr. DeYoung's testimony. Timothy had signs of hypothermia. How does a 15-year-old in Michigan in July get hypothermia? By sitting in an ice bath for hours upon hours upon hours at a time. And that's what Timothy went through on the last day of his life. Tortured with a pizza roll that he could eat. Cold water repeatedly dumped on him. Repositioned if he started to feel comfortable. And she's watching everything. She's directing everything. Serious mental harm. I mean, any injury to a child's mental condition that results in visible signs of an impairment of the child's judgment, behavior, ability to recognize reality, or ability to cope with the ordinary demands of life. That's a no-brainer. The level of mental harm inflicted on Timothy is difficult to grasp. How a 15-year-old already with special needs, sensory, the sensory issue that she described, she's punishing him with hot sauce. She's punishing him with ice baths. She's punishing him with alarms that make noise that affects his ears. She's depriving him of sleep. She's depriving him of movement. She's depriving him of clothes. She's locking him in a closet. If that's not serious mental harm, then I don't know what is. Again, these are all at her direction. And don't let her off the hook, ladies and gentlemen, just because she stood up here and said yesterday, I didn't intend for these things to happen. Of course you intended for these things to happen. Of course you intended for these things to happen. She's guilty of first-degree child abuse. It's also the people's position that she's guilty of first-degree felony murder. If you find that she's guilty of that first-degree child abuse, you turn to the analysis of the murder charge here. And in order to prove first-degree murder, first, that the defendant caused the death of Timothy Ferguson. That is, Timothy Ferguson died as a result of starvation and or physical abuse, physical neglect and abuse. You heard Dr. DeYoung's testimony about the cause of death for Timothy here, and all you needed to do was look at the photograph to see how he died. And again, I wish I could have spared everybody from seeing those photographs, but I can't, because I have to prove, and this is why, I have to prove how he died. The defendant has one of these three states of mind. She intended to kill, she intended to do great bodily harm to Timothy Ferguson, or she knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of her actions. Let's talk about that first one for a moment. She intended to kill. I wish I could stand up here and tell you that I think she actually didn't have the intent to kill. I wish I could do that, because the notion that you could starve a child to death intentionally over months and months, which is what it would take, I wish she didn't have that intent. I wish I didn't believe that she had that intent. And it's for you to decide whether or not she had that intent, but her actions sure show that she had that intent. If she wanted to kill Timothy, I wish she'd done it a lot faster than what she did, because what he would have had to have gone through in those last few days or few weeks is unthinkable. She had that intent to kill him. At a minimum, she had an intent to do him great bodily harm, and you can find either one. And even if you had to struggle with finding that, she knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of his actions. She made a situation so dangerous, so obviously dangerous to anyone, especially someone of her intelligence level, that death or great bodily harm was the likely result. Well, death was the result. Death was the result because of what she did to him, because of the things that she directed to be done to him. On the stand yesterday, she tried to say, well, some of this was Paul's idea. Paul did this, and Paul did that, and Paul did this, and Paul did that. If you need to, feel free to review these text messages. If you want, you can review the bigger binder of text messages, because these are all about Timothy as well. And when I say they're about Timothy, they're not about Timothy, all the good things that he's done, all the good things we're going to do. It's all about the punishments. This is a small window. This is a larger window into the life, to the hell that Timothy's life was for the last 6 months. Every step of the way, her directing, her telling, her ordering, her threatening Paul to do the things. This was not on Paul. I told you in opening that you may not like Paul Ferguson. And I do believe that he is also in part responsible for Timothy's death here. But you had an opportunity to see Paul testify here. Did that look like the mastermind behind this? Or did that look like, as he put it, somebody who was just desperate for attention, desperate for the love of his mother, and doing the things that she wanted him to do? That's for you to decide, but I submit to you, ladies and gentlemen, that's what it was. That Paul was doing what she told him to do, because he knew what was going to happen to him if he didn't do those things. Quite simply, ladies and gentlemen, as I've said, this is a case of first-degree felony murder. The underlying felony being first-degree child abuse. That's the other element that you need to find happened here, that she committed that felony first-degree child abuse. And if you find those two things, if you find that she committed the first-degree child abuse, and that she had one of those three states of mind, and it doesn't matter which one you decide, but if she had any one of those three states of mind as it related to Timothy, then she's guilty of first-degree felony murder, and she's guilty of first-degree child abuse. Ladies and gentlemen, Timothy Ferguson, to the defendant, had ceased to be a person. Timothy Ferguson had become less than the animals that she trains. You heard her say it would never occur to her to do the things that she did to Timothy to the animals that she trains, to the dogs that she trains. He was less than a dog to her. And this was a fight that he was not going to win. But don't take my word for it. Of course, I had it tabbed. July 29th. And even if he sits up right before you get there, as you get there, I honestly don't care if you get a little rough with him. July 29th again. Trust me, I know he's thin. That being said, he told me a week and a half ago that he wanted to be thin to make me feel bad for punishing him. This is supposedly when he's on his hunger strike. You don't get to grump at him for that, though. I already lit into him for it. Cleaning up the rooms, directing Paul to make sure that he cleans up the rooms. And please check the carpet to see if it needs to clean that too. There's some different awesome cleaner for the carpet that he can use if he needs to. He will need to use a different green and yellow sponge for that. I do not want him using my nice sponges for either of those. July 1st, after the photograph that she's got. Might be best if you give him like 4 pieces of bread to eat before he starts work, just to make sure he stands up while he eats them, please. That way he has no excuses. July 1st, the camera in his room needs to be picked up, please. Ugh, lots of hot sauce for that. What do I do if he doesn't finish within the assigned time? Hot sauce. These are all after that photograph. So apparently this hot sauce isn't just Carolina Reaper, it's the Trinidad Scorpion chili pepper. Yep. While he's on a hunger strike, on July 5th, the day before he dies. Forgot to tell you this before I left. Timothy was doing his fake stumbling and falling last night, of course, so I decided to prove once again how fake it is. I asked him if he would stop doing that if he would eat a whole pizza by himself, and he said yes, of course. And then I told him how obvious it was that he was being fake, and he had just proven that yet again, and of course he just looked down and didn't respond. Can't say it any more blunt than she does. She was not going to let Timothy win. Plain and simple. And if that many died, then many died. He dies, she kicks into survival mode and starts to lie to the police. That alone evidences a guilty state of mind, ladies and gentlemen, but you don't need that. You don't need much more than these text messages to prove that Shanda Vander Ark is responsible because she intended to kill, because she intended to do great bodily harm, or she at least created a situation so dangerous that death or great bodily harm was a result to her child, Timothy Ferguson. And I will ask you to return a verdict of guilty of first-degree felony murder, first-degree child abuse. Thank you.
Thank you, Mr. Roberts. Mr. Johnson.
Thank you, Your Honor. Good afternoon, ladies and gentlemen. All right. Everybody ready? Need a moment? You all good? Okay. I'm a child of the late 50s and grew up in the 60s and 70s, and during that period of time, and even the 80s and 90s, when you remember something, it was in your head. It was something that was up here, and a memory was up there, and that's where the memories were. That's where we kept them, and it was a great system because they were all there, and if called upon to respond to a memory, a situation, an issue, the entire memory and its context will come tumbling out. Then we started doing something in the aughts and the tens and the 20s, where we started having these devices called cellular phones. And in those cellular phones, they have this thing on them called text messaging, where you can write down whatever's going through your head at the moment and send it. It's a great system. I mean, let's face it, we all use it because it works, and it works well, and it's very utilitarian, and we love it. But I think if we had a chance to think about it, we'd all admit that what you text isn't everything that's going on. That what you text doesn't tell the whole story. The text you sent today don't tell the whole story of your whole day. They just tell a portion of it. They tell a snippet. They tell a story. But they probably don't tell what happened to you from the time you got up and you couldn't find your left shoe to the time you're going to go to sleep tonight and wishing you had an extra slice of that pie for dessert. It doesn't tell you all that stuff, right? It tells you a snippet. It tells you a bit. It doesn't tell if you're mad or you're kidding or you're suggesting or you're tired or you didn't spell check before you sent it. So it says go when you want to say goat. It doesn't tell any of that stuff. It tells you a snippet. It tells you a portion. It tells you a particle. And that's what text messages do. The greatness of text messages are they're great. It's in the message. The weakness of them is they don't tell the whole story. And if someone were to grab someone's phone and look at what they did from a year and a half ago and try to figure out what they were thinking based on their text, they'd know that snippet, but they wouldn't know I'm venting. They wouldn't know that I don't take this serious. I don't mean this seriously. They wouldn't know that even though I'm mad at you, I still love you, because that's the part in the text is going to be you didn't clean your room, and that's it, because that other part isn't with it. The other part, our communication, even when I speak to you right now, our communication is the words that come out of my mouth are only about 35% of what information you're taking in. You're watching my body language, you're listening to the sound of my voice, you're listening to the context, you're looking at the situation. That fills in the other information that you're going to need to have in order to figure out, with the most powerful computers that known to man, our brains, what I really mean and what I'm really saying. If you have all you have is a text, ladies and gentlemen, it's like watching a movie with no picture. All you hear is the voices in the background. Somebody has to explain to you what else is going on in that scene. That's what we have here. We have a series of texts. We have a series of texts that people can select and jump around in terms of not just times and dates and times of day and without reflection on the circumstances. You're at work, you have time to send a 3-second text before the judge calls you and says, come do something else. Or you're sitting in your living room, you're reading a book, and you can take your time with these texts. It doesn't tell you any of that. So what comes out to you is a distorted picture. My suggestion, someone takes your text, what comes out to you is a distorted picture. It's not the whole story. It's not the whole situation. It doesn't tell the whole thing. All the texts that you've written do not tell you the whole story of your life. It tells you what they refer to at that moment, and that's it. And the rest has to be inferred. If someone comes along and takes it out of context, and takes it out of circumstances, and it takes it out of where it existed at the time you sent it, you have a different story than what was intended. The communication you're getting is different than what you intended. That's problem number one. Problem number two is when you take those texts and you back them up with somebody who's highly motivated to lie. Ladies and gentlemen, they didn't have supercomputers back when they invented the theory of relativity. When Einstein, he didn't have a supercomputer. They hadn't been invented yet. What Einstein used to do famously, he used to call them thought experiments, where he'd imagine a situation and then he tried to think his way through. He was pretty good at it. He kind of changed life on the planet doing this. He kind of changed life on the planet. Now, you've been told that Paul's deal was that he had immunity from prosecution for whatever he talked about, and he'd get a sentencing recommendation or something like that. And there was one other thing, I forget, it doesn't matter. There's three things you were told he said. He's charged with child endangerment, child abuse in the first degree. Okay. And you were told that by our judge that you can believe all of what somebody says, part of what somebody says, or none of what somebody says. You were told that was Paul's deal. I'm going to invite you to it. And that Paul could be charged with first-degree murder, which Paul told you from the stand. I asked him, do you know what the penalty for that is? I sure do. He could be charged with first-degree. Now, I want you to do this thought experiment. You're a lawyer. You're Paul's lawyer in this thought experiment of my making. And the prosecutor calls you and say, I want to use your client to testify against his mom. And you say, okay. And then you have the client testify. And then he testifies, he does everything he's required to do, everything he wants, they want it, he gives them, everything he could, he gives them. And then at the end, once he's done testifying, his lawyer finds out they've charged his client with first-degree murder anyway. After all, that wasn't part of the deal, right? He could be charged with first-degree murder. Paul could be, theoretically, it's not part of the deal, could be charged with first-degree murder, even though he's fully performed. What would, in this thought experiment, what would your reaction be? That you sent your client in, he did everything he was told, and he still gets charged with first-degree murder. Might I suggest to you that you might be a little upset with that? Might I suggest to you that if you were informed that after Paul has performed and you're his lawyer, and he's still getting charged with first-degree murder, that you're going to be upset. And I further suggest that you're going to tell everybody, you're going to tell all of your defense friends, all your defense lawyers, you're going to tell them, this is what they did to me. When do you think the prosecutor is going to get another defense attorney to serve your client up again, if you did that? When do you think they're going to get another defense attorney in this county, and your thought experiment, to serve up their client, if he does what he's supposed to do and he still gets charged in the circumstances like we've described? Well, you know what the answer is. You know what the answer is. In your thought experiment, you can figure out this is what is not going to happen. Because you know what's going to happen when the defense community is going to find out what happened with Paul and his testimony. He did what he's supposed to, still got charged with first-degree murder. He did what he's supposed to. He's not going to be able to get, the prosecution is not going to get another defense attorney to come forward and give up their client again. This is part of something that's obvious, and it doesn't have to be in writing. Everybody, if you do the thought experiment, it's in writing. It's not in writing, but you can do the thought experiment. You can bet your house Paul's not going to get charged with first-degree murder. You can bet your house that Paul's deal is not his immunity. Paul's deal is that no first-degree murder. That's his deal. Paul is highly motivated to tell you the story that will keep him from getting that charge. And he did. Read his own text. Paul's the one who's talking about, I wish I could beat him up. I've never wanted to beat up somebody more in my life. Paul's the one who kicked in the door. Paul's the tormentor. Paul is the guy who's not only tormenting his brother, he's also enjoying it. And Paul is motivated to say now, and Paul testified against his mom. Paul tortured his brother. That's who Paul is. And Paul ain't going to be charged with first-degree murder. I don't care what the deal is. I think that should be obvious. So you got the two bits. You've got these text messages that give you a false and misleading representation of what people are thinking. You've got Paul sitting here talking for his life, talking his butt off. He's trying to get out from under. In fact, at one point I asked him, "Isn't it true you wrote a letter to your mom saying you wish it just ended all so you could get out of this thing?" And he said, "Yes, I did." That's who Paul is. Paul's also the nexus of information for my client. Yes, my client, he told my client one time that he thinks he's thin, we should feed him, but on another time, in fact, right before his death, Paul says, no, he's fine. Paul is the nexus of information. If you have those cameras, these security cameras in your home, you recognize those are great devices, and generally speaking, they do the job. But the kind of detail, the kind of vision that you need, you really need Paul there to augment that so that you get a full picture of what's going on. And Paul was there, and he was providing for my client. Third factor. I got a client that forgot everything. She forgot her name, if you were asking. She forgot everything, let's face it. Okay. When Mr. Roberts was given his open, and quite frankly, I've been doing this for 35 years. That's one of the finest openings I've ever heard. It was just wonderful. It was those kinds of things that lawyers appreciate because it was so well crafted, so well delivered. And he even gave you some poetry, and I'm no poet. I can't match that. I look for stuff, but I can't find anything like he did. It was just a wonderful opening. What I got for you is a little bit of physics. 20 years ago, 30 maybe, I read that the smallest bit of matter theoretically possible to exist in the universe would be about 2/100,000th of a billionth of a millimeter. And it would be a thing. It would be two-dimensional. It would be a thing that's so high energy that it could only exist for a brief moment in time. It exists and it pops out of existence again. I read that 30 years ago. I couldn't tell you the first name or last name of any people in this panel right now. It's not because it's not important. It's because that's the way memory works. I couldn't tell. That's the way memory works. It is not a logical construct where you remember things that you're supposed to, but you can forget the things you don't. Memory remembers what it wants to remember. Now you can do techniques and training to do, and if something say someone that causes a lot of adrenaline or something that burns the memory into you, you remember that. You remember when your child was born, because that's the sort of situation it is. But otherwise, memory has its own mind, and it remembers what it wants, and it forgets what it wants. And to say, well, she didn't remember these things, well, yeah, she probably doesn't. You know, we talked about, and to use Mr. Roberts' example, at one moment my client is talking about getting fries for the younger child, but getting hot sauce for the older child. And he talks about compartmentalizing. The brain is a sophisticated organism, it's a sophisticated panel. It will organize things according to whatever parameters that are there, but it will separate things out. And it is my argument. The argument we've made from the very beginning is that while part of her knew she was punishing this boy, none of her knew that she was hurting him. I understand. There's two possibilities. One, she's exactly what Mr. Roberts said, and that's evil. That's evil. Or the other possibility is there's something going on, and she doesn't understand. She didn't understand, despite all the intelligence. She didn't understand the ultimate consequence of those individual acts of punishment. The accumulated force and power and weight of those individual acts of punishment. She didn't understand it. She didn't see it. I don't know how that could be. But to be honest with you, that's what makes sense. It makes sense because this is her son. And she raised other children, her own flesh and blood. She raised them and didn't do this sorts of things to them. Something was going on where she didn't understand it. This child was probably the highest needs. She didn't understand it. And this, and her personal situation also makes a difference. Look, she took this child in when she wasn't supposed to have him because there was no other choice. So she did it. She raised another child. Paul has special. Paul's 20 years old and living at home with mom and working minimum wage. This is what Paul's doing. She has other child, and she has the demands of judges and lawyers, and she has the demands of education and the demands of ambitions, and her husband gets a stroke. These all make a difference. That's why I'm talking about context. Give him 4 slices of bread with hot sauce on it. Doesn't talk about, she's thinking about her husband. The impact is how she's going to pay the rent. How she's going to get to work tomorrow. There's no gas in the car. These are all things that are going. There isn't a situation where she's sitting there just thinking about this one problem. She has too many problems to think about one. She's thinking about them all at a time. And pressure busts a pipe. It was too much. She didn't hate her child. That's what it would have taken to knowingly do this to your child. She would have to hate him. A child makes you angry. A child makes you frustrated. A child makes you tired. A child is willful. And this is and she wasn't able to cope with it. And she didn't add it up. The bread plus the water plus the standing against the wall. She didn't add it up. And the mind is a powerful thing. She didn't see what we all saw. But let me. So this woman who doesn't love her son, according to the people, comes into a room and she says, "Timothy, please, no. Wake up. Come on, buddy. No. This can't happen. Is he okay? Is he okay? He's not stiff. Please, baby, come on. Open his jaw for me. Please, come on. Come on, buddy. You're okay. Come on, buddy. Come on, Timothy. I don't understand." To which Paul says, "I don't either. Come on, buddy. Come on, sweetie. Come on, buddy. Come back to us. Come on, buddy. Come on, buddy. Come on." Does she get scared of that? Yep. And lie to please. Hell yeah. She does. A lot. Because like Paul, she can see it now. Now, she doesn't have to do the math. The math is the body of her dead son. And they can both see it now. But as they were going through it, folks, they didn't see it. I don't think at the moment that they find the body and they says, I don't understand, and Paul says, I don't either. They were faking it for the camera or faking it for the police. They've forgotten all about the damn camera. They said those things because that was true. It's what you do in those moments of high stress. It's true. I didn't get this. I didn't see this coming. How could you not? They didn't. They didn't see it. Neither one of them saw it. Paul talked about, in his few moments of clarity, I loved my brother. I wish it was me instead of him. And that's how, did he start feeling that way afterward, or did he feel that way at the time? If he felt that way at the time, how could he do these things? Because he didn't know he was doing these things. You see where I'm going? How could he feel? I'll repeat. He said he'd give his life for his brother if he could. Question is, did he feel that way at the time he was doing these things to him? Well, how could he do those things to him if he felt that way? Because they didn't see it. These people committed manslaughter. That's what they did. They caused this boy's death, but they didn't intend to. That's simply it. We're asking that you, when you do your deliberations, that you consider that. I understand what those pictures look like. I understand what they look like. I understand that everybody here wants justice for Timothy. I get that too. Justice is the conviction of a person for what they did, not for what they made us angry about, not what they made us sick about, not what they made us want to jump over that railing and take care of this thing ourselves. That's not what justice is. Justice is, this is what you did, and this is what you pay for. Thank you, ladies and gentlemen.
Mr. Roberts.
Thank you, ladies and gentlemen. Because I do bear the burden of proof in this case, I do get one more opportunity to address you. And I want to start by thanking Mr. Johnson for his compliments here. We tried a number of cases together over the years, and it's always, quite frankly, it's always a pleasure to work with Mr. Johnson. And I think a lot of folks are probably confused sometimes when they see a relationship, a good relationship between both sides. And what I always tell people is this is an adversarial system by its nature, but that doesn't mean that the parties necessarily have to be adversaries. We don't have to agree on everything, and ultimately, that's why you folks are here. Let's start with Mr. Johnson's comments about the text messages and how text messages don't show all of what a person is doing. He's right. They don't show all of what a person is doing or necessarily even what a person is thinking, but they do offer a window into the insight of what a person is thinking about. They do offer a window into what a person is telling somebody else to do or telling somebody else to say. So the fact that there are that binder full of text messages over a 6-month period about what to do to punish Timothy offers you a window into the inside of the defendant. But actions are what speaks louder than words here. Because everything that she talked about, everything that she wanted to have done, with the exception of one thing, so out of bounds, I can't even believe she posed it, but everything that she wanted to have done was done. That's not text messages, that's her actions. Her actions, not her text messages, caused Timothy's death. Her actions, not her text messages, caused Timothy to suffer serious emotional, mental, and physical harm that resulted in his death. Withhold the food. Give him bread with hot sauce. Put him in an ice bath. Make sure he doesn't sleep. Make sure all the food is locked up. Make him run the stairs. It goes on and on and on and on. Her actions speak louder than her words. Mr. Johnson talked to you about Paul. And I'll leave you to your recollection of what Paul's deal was, but Mr. Johnson summarized it fairly well. There is not an agreement in place that Paul is not charged with murder in this case. Ultimately, that's a decision that our office gets to make. So he wants you to look at Paul's testimony through that lens. Go ahead. Please do. What did Paul lie about? What did Paul get on the stand and tell you that wasn't true? What did Paul get up there and describe what he had done to Timothy at Shanda's direction that didn't happen? Nothing. Mr. Johnson cited nothing for you to look at in Paul's testimony that wasn't true. And he can't, because every single one of them. And again, the only thing he didn't do, and he's the one that drew the line, the only thing he didn't do was when the day before her child dies, as she's looking at him in an ice bath for hours upon end, and says, hey, crazy idea. What would it feel like if hot sauce was poured on your private parts? I'm not saying touch him there or anything, but what do you think? Are you kidding me? That's why I said yesterday, did you even need to ask that question? What do you think? That's what's in her mind. That's how you determine what her intent is. That's what the instructions are going to tell you to do. This isn't a tiny glimpse of her. This isn't a tiny moment in time, and you can't assume that that's what she is. You can assume that's what she has done for the last 6 months. Because that's what this is about. That's what these text messages are about. Every single one of them. Right up until the very end. The last thing she says to Paul before they find Timothy that next morning is, I had to drag him back into the small room. He decided to go big or go home today. The last thing she says to her child, you don't have to breathe with your mouth open, dummy. Her actions, what makes her guilty? The text messages are just evidence to support the actions that she took. Paul aided and abetted in the death of his brother. There's no question about that. He did these things. But you saw Paul. You heard him talk about what limitations he has. You heard him talk about what type of person he was. But you know what Paul is not? Paul is not Timothy's father. Paul is not the person charged with the care and custody and love of his brother. He can love him. And as he said, I guess I didn't love him enough. It's up to you whether you believe that was genuine or not, but even if you believe it wasn't, even if you believe his emotion about this and his remorse about this is fake, he didn't lie about anything else. It's all proven. And let's just assume for the sake of argument that Paul is the mastermind behind all of this. Paul's responsible for everything. Why do you leave him alone with him? If you're the parent, why are you leaving your child alone with somebody who's this monstrous? It doesn't make any sense. The reason Paul is left to watch over him is because Shanda can manipulate Paul into doing the things that she needs to have done. She knew she had somebody in Paul that would carry out her instructions implicitly. I'm glad she stopped Paul from being physical with Timothy. I am. I appreciate that the one thing he did not actually have to suffer as a result of this were beatings. But everything else was just to isolate Timothy from the world. Look at the lengths she went to make sure that the grandmother of the youngest child couldn't come to the home. To the point where she's tracking her on her phone when she's driving home from work. Now, I don't like it when my in-laws come over and my house is dirty, but I'm not looking at my phone to see when they're going to get here or make sure I meet them outside so they don't come inside. You only do that because you're trying to hide something. What is she trying to hide? She's trying to hide Timothy. Because anybody that would have seen Timothy, anybody that looked at that child would have known what was going on. And she couldn't have that. And her mind is working well enough to know, I can't have people seeing Timothy. I can't have photographs of Timothy. I need to have Paul do these things. I need to make sure that Timothy doesn't get to go outside. Did you hear her say anything about anywhere that Timothy got to go? The closest she came to saying, well, the backyard is kind of open and you can kind of see in the backyard. She talked about taking him to Craig's Cruisers or taking him to a movie or taking him to a restaurant, any of that stuff? No. Timothy was a prisoner, treated lower than a human, treated lower than an animal in his own home. A prisoner in his own home. The 911 call. She said all those things. You heard all those things. I'll leave it to you to determine whether or not the emotion that she's displaying there was real. Sounds cold. Yeah, she's upset. She's upset that he's dead. But if you're so worried, if you're so concerned, if you're so alarmed, if you care so much about this person, why do you wait 18 minutes to call 911? Why, when your son, who's 20 years old, says to you, I think we need to call an ambulance, or should we call an ambulance? You say, no, not yet. Not yet? Not yet? When? When you're done making it sure, like, you're covering up as much evidence as possible? Because that's when. Because then it becomes a matter of making sure he's got pants on and put your belt on to make sure he looks, that he's looked this way. Make sure we tell him he was on a hunger strike. And now I guess we'll have to call 911. Not yet. Don't call 911 yet. What are you waiting for? To get the story straight. Guess I'm going to be late for work. You heard Paul up here yesterday say that he'd trade places with Timothy if he could. Did you hear the defendant say that? Mr. Johnson said she had so many things on her mind. It was just, this was just one thing too many. He's right. Timothy was the one thing too many. Timothy was too much for her. And as a result, she decided she wasn't going to lose this fight. Timothy was too much for her to handle, but she was going to win. And again, don't take my word for it. February 16th, 5 months before Timothy dies. I may need some help with it, but I'm about to get a lock for the pantry door. Remember what she said about the pantry? And a lock for the fridge and both freezers, and then we won't leave any food out in those areas, and he won't have access to unlock those. This is supposedly February 14th. This is when he's on a hunger strike because of Adam's stroke, right? So your child's on a hunger strike and you're locking away the food? Paul's response, okay. If you disagree, please say so, but he is not going to win this. There it is, ladies and gentlemen. She was bound and determined that she was going to win. Timothy was no longer a human to her. Timothy was something even below the dogs that she trained. But she was going to make sure that she won this fight. Ladies and gentlemen, it is now up to you to send a message to her that she lost this fight. Thank you.
All right, thank you, Mr. Roberts. Yes. Good. Okay. Well, Mr. Is that can you use the restroom?
No, sir.
Okay, all right. All right. Members of the jury, the evidence and the arguments in this case have finished, and I will now instruct you on the law. That is, I will explain the law that applies to this case. Remember that you have taken an oath to return a true and a just verdict based only on the evidence and my instructions on the law. You must not let sympathy or prejudice influence your decision. As jurors, you must decide what the facts of this case are. This is your job and no one else's. You must think about all the evidence and the testimony and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It's my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I have given you some instructions about the law. You must take all of my instructions together as the law you are to follow. You should not pay attention to some instructions and then ignore others. To sum up, it's your job to decide what the facts of this case are, to apply the law as I give it to you, and in that way decide this case. As I've repeatedly said, a person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of a crime beyond a reasonable doubt. The defendant is not required to prove her innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair and honest doubt growing out of the evidence or lack of evidence. It's not merely an imaginary or a possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. When you decide this case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it's important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything that I have told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. The lawyer's statements and arguments are not evidence. They are only meant to help you understand the evidence and each side's legal theories. The lawyer's question to witnesses are also not evidence. You should consider these questions only as they give meaning to the witness's answers. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. My comments, rulings, questions, and instructions are also not evidence. It's my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give instructions, I am not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all of the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. As I said before, it's your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You're free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have based on race, gender, national origin of the witness. There's no fixed set of rules for judging whether you believe a witness, but it may help you to think about the following questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that may have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions or argue with the lawyers? Does a witness's age and maturity affect how you judge his or her testimony? Does a witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does a witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does a witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly but simply be wrong about what they thought they saw or remembered. It's also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. The prosecution has introduced evidence of a statement that it claims the defendant made. Before you may consider such an out-of-court statement against the defendant, you must first find that the defendant actually made the statement as given to you. If you find that the defendant did make the statement, you may give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made and about all the other evidence in the case. You may consider the statement in deciding the facts of the case and in deciding if you believe the defendant's testimony in court. Facts can be proven by direct evidence from a witness or exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you were to look outside and see rain falling, that would be direct evidence that it's raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So in my example, if you were to see a person come in from the outside wearing a raincoat covered with small drops of water, That would be circumstantial evidence that it's raining. You may consider circumstantial evidence. Circumstantial evidence by itself, or a combination of circumstantial evidence and direct evidence, can be used to prove the elements of a crime. In other words, you should consider all the evidence that you believe. You have heard evidence that before the trial, a witness made a statement that may be inconsistent with her testimony or his testimony here in court. You may consider an inconsistent statement made before the trial to help you decide how believable the witness's testimony was when testifying here in court. If the earlier statement was made under oath, then you may also consider the earlier statement as evidence of the truth or of whatever the witness said in the earlier statement when determining the facts of this case. You may consider whether the defendant had a reason to commit the alleged crime, but a reason by itself is not enough to find a person guilty of a crime. The prosecutor does not have to prove that the defendant had a reason to commit the alleged crime. He only has to show that the defendant actually committed the crime and that she meant to do so. You should not decide this case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and the evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You have heard that a lawyer or a lawyer's representative talked to one of the witnesses. There's nothing wrong with this. A lawyer or lawyer's representative may talk to a witness to find out what the witness knows about the case and what the witness's testimony will be. You have also heard testimony from a witness, Dr. Joyce DeYoung, who has given you her opinion as an expert in the field of forensic pathology. Experts are allowed to give opinions in court about matters they are experts on. However, you do not have to believe an expert's testimony or opinion. Instead, you should decide whether you believe it and how important you think it is. When you decide whether you believe an expert's opinion, think carefully about the reasons and facts she gave for her opinion and whether those facts are true. You should also think about the expert's qualifications and whether her opinion makes sense when you think about the other evidence in this case. You have heard testimony from witnesses who are police officers. That testimony is to be judged by the same standards as used to evaluate the testimony of any other witness. The defendant is charged with counts, that is, with the separate crimes of homicide, open murder, and first-degree child abuse. These are separate crimes, and the prosecutor is charging that the defendant committed all of them. You must consider each crime separately in light of all the evidence in the case. The defendant is charged with first-degree felony murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Timothy Ferguson. That is, that Timothy Ferguson died as a result of starvation and/or physical neglect and abuse. Second, that the defendant had one of these three states of mind. She intended to kill, or she intended to do great bodily harm to Timothy Ferguson, or she knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of her actions. Third, that when she did the act that caused the death of Timothy Ferguson, the defendant was committing or attempting to commit or helping someone else commit the crime of first-degree child abuse. For the elements of the first-degree child abuse must be proven by the prosecutor beyond a reasonable doubt, and those elements include the following. First, that Shanda Vander Ark is the parent of Timothy Ferguson. Second, that the defendant either knowingly or intentionally caused serious physical harm and/or serious mental harm to Timothy Ferguson. Third, that Timothy Ferguson was at the time under the age of 18. By serious physical harm, I mean any physical injury to a child that seriously impairs the child's health or physical well-being, including but not limited to brain damage, a skull or bone fracture, subdural hemorrhage or hematoma, dislocation, sprain, internal injury, poisoning, burn, or scald or severe cut. By serious mental harm, I mean an injury to a child's mental condition that results in visible signs of an impairment in the child's judgment, behavior, ability to recognize reality, or ability to cope with the ordinary demands of life. The fourth element of first-degree felony murder is that the killing was not justified, excused, or done under circumstances that would reduce it to a lesser crime. Determining whether the act causing death occurred while the defendant was committing or attempting to commit or helping someone else commit the crime of first-degree child abuse, you should consider the following. 1, the length of time between the commission of first-degree child abuse and the murder. Second, the distance between the scene of the first-degree child abuse and the scene of the murder. Third, whether there is a causal connection between the murder and first-degree child abuse. Fourth, whether there is a continuity of action between first-degree child abuse and the murder. Fifth, whether the murder was committed during an attempt to escape. You may also consider the lesser charge of second-degree murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Timothy Ferguson. That is, that Timothy Ferguson died as a result of starvation and or physical neglect and abuse. Second, that the defendant had one of these 3 states of mind. She intended to kill, or she intended to do great bodily harm to Timothy Ferguson, or she knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of her actions. Third, that the killing was not justified, excused, or done under circumstances that reduce it to a lesser crime. You may also consider the lesser charge of involuntary manslaughter. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Timothy Ferguson. That is, that Timothy Ferguson died as a result of starvation and or physical neglect and abuse. Second, in doing the act that caused Timothy Ferguson's death, the defendant acted in a grossly negligent manner. Gross negligence means more than carelessness. It means willfully disregarding the result to others that might follow from an act or failure to act. In order to find that the defendant was grossly negligent, you must find each of the following 3 things beyond a reasonable doubt. First, that the defendant knew of the danger to another. That is, she knew there was a situation that required her to take ordinary care to avoid injuring another. Second, that the defendant could have avoided injuring another by using ordinary care. Third, that the defendant failed to use ordinary care to prevent injuring another when, to a reasonable person, it must have been apparent that the result was likely to be a serious injury. The defendant is also charged with the crime of first-degree child abuse. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that Shanda Vander Ark is the parent of Timothy Ferguson. Second, that the defendant either knowingly or intentionally caused serious physical harm and or serious mental harm to Timothy Ferguson. By serious physical harm, I mean any physical injury to a child that seriously impairs a child's health or physical well-being, including but not limited to brain damage, a skull or bone fracture, subdural hemorrhage or hematoma, dislocation, sprain, internal injury, poisoning, burn or scald, or severe cut. By serious mental harm, I mean an injury to a child's mental condition that results in visible signs of an impairment in the child's judgment, behavior, ability to recognize reality, or ability to cope with the ordinary demands of life. Third, that Timothy Ferguson was at the time under the age of 18. It's not a crime to discipline a child. A parent may use force to discipline a child, but this does not mean that any amount of force may be used. The law permits only such force as is reasonable. The defendant is not required to prove that the acts alleged here were reasonable. The prosecutor must prove beyond a reasonable doubt that the force used was not reasonable as discipline. The defendant's intent may be proved by what she said, what she did, how she did it, or by any other facts and circumstances and evidence. You must think about all the evidence in deciding what the defendant's state of mind was at the time of the alleged killing. The defendant's state of mind may be inferred from the kind of weapon used, the type of wounds inflicted, the acts and words of the defendant, and any other circumstances surrounding the alleged killing. In this case, the defendant is charged with committing open murder and first-degree child abuse or intentionally assisting someone else in committing it. Anyone who intentionally insists someone in committing a crime is as guilty as the person who directly commits it and can be convicted of that crime as an aider and abetter. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the alleged crime was actually committed either by the defendant or someone else. It does not matter whether anyone else has been convicted of that crime. Second, that before or during that crime, the defendant did something to assist, counsel, aid, or abet the commission of the crime. Third, at the time the defendant must have intended the commission of the crime alleged, or must have known that the other person intended its commission, or that the crime alleged was a natural and probable consequence of the commission of the crime intended. It does not matter how much help, advice, or encouragement the defendant gave. However, you must decide whether the defendant intended to help another commit the crime and whether her help, advice, or encouragement actually did help, advise, or encourage the crime. The evidence must convince you beyond a reasonable doubt that the crime occurred on or about July 6, 2022 within Muskegon County. When you go to the jury room, you will be provided with a written copy of the final jury instructions. You should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a businesslike way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communications equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is not necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately each of you will have to make up your own individual mind. Any verdict must represent the individual considered judgment of each juror. It's your duty as jurors to talk to each other and make every reasonable effort to reach an agreement. Express your opinions and the reason for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide that you were wrong. Try to work out your differences. However, although you should try to reach an agreement, none of you should give up your own honest opinion about the case just because the other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. If you have any question about the jury instructions before you begin deliberations or questions about the instructions that arise during deliberations, you may submit them in writing to the bailiff. Possible penalties should not influence your decision. It's the duty of the judge to fix the penalty within the limits provided by the law. If you have any questions or wish to communicate with me while you're in the jury room, please have your foreperson write a note and give it to the bailiff. It's not proper for you to talk directly to the judge, lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, you are permitted to take your notes and full instructions. If you want to look at any or all of the reference documents or exhibits that have been admitted, you simply need to ask for them. When you go to the jury room, you will be given a copy of the written instructions that I've just read. As you discuss the case, you should think about all of my instructions together as a law you are to follow. When you do the note, there's a doorbell back there. I think you guys have already seen it. If you have a question, write it down, fold it in half. Just ring the doorbell. Mr. Weaver will come in. He'll say, we have a question. Do we have a verdict? He'll ask you. You say, yep, here's the question. He'll bring that back out. Give us a few minutes. Essentially, we do questions on the record, okay? So we don't just all gather in chambers and answer the question and then send it back in there. We want to make sure there's a record that what question was asked. So typically, it takes us a little minute to get everything assembled again, and then we'll bring you back in if we can answer the question, and we'll actually answer it in open court, okay? So that's kind of the process, and again, please be patient. It's not as simple as it comes to me, I write down the answer, and I send it back. There's a little more to it. So I have prepared a verdict form listing the possible verdicts. The verdict form that you'll receive says State of Michigan, the 14th Circuit Court, people of the State of Michigan versus Shanda Vander Ark, has my name, the file number. It says verdict form, possible verdicts. You may return only one verdict on each count. Mark only one verdict for each count. Count 1 is charging open murder involving the death of Timothy Ferguson. There's boxes for not guilty, guilty of first-degree felony murder, guilty of lesser offense of second-degree murder, and guilty of lesser offense of involuntary manslaughter. Count 2 is first-degree child abuse, and there's 2 boxes, not guilty and guilty. Under each count, you are only permitted to mark 1 box. That's important. And it says that on there, but sometimes it happens. So, and then on the bottom, it says date, and whoever the foreperson is, just date it and sign it. If you reach a verdict, then simply, again, take it, fold the verdict form in half, ring the doorbell, tell Mr. Weaver, do not give him the verdict form. You hang on to that. What will happen is we'll bring the jury out. Whoever that foreperson is, I'll essentially address the jury and say, if that's a verdict, would the foreperson please rise? They'll read that. Mr. Weaver will collect that from whoever the foreperson is, give it to me so I may review it, and then we'll give it back to whoever the foreperson is to pronounce the verdict in open court. That's the procedure we'll follow. So at this time, we need to do our blind draw to slim our jury down to 12. If you could do that, Mr. Weaver.
Juror number 3.
Okay. You know what, I usually have my list up here, and for some reason, oh, wait a minute, hold on. Mr. Crowley. It's wherever the alternate is. Actually, why don't we just call the alternate before we do that?
Number 1.
Okay, Miss. We, in any case, quite frankly, the alternates, typically what we'll do is I'm directing you not to talk about this case with anyone. We do that because potentially something could happen during deliberations. We now only have 12, and if somebody goes down and you guys have talked about the case or started looking up information, it creates a problem because we may bring you back to say, okay, we've lost a 12th juror. We need one in here and bring you in, okay? I want you to go through the door here when you're excused. Ms. Deaton will get your phone numbers, and if the jury reaches a verdict or when this case is done, Mr. Weaver will call you and simply say you are now free to talk about this case with anyone you wish, okay? So at this time, I'll have you go with, well, before we do that, you want to have him, and then you'll come back out, or what do you want to do?
I just bring it back to Ms. Deaton.
Okay, so they're bring back, he's got to come back out so I can swear him in, but if you go ahead and go with Mr. Weaver right now, he'll take care of you. Do you solemnly swear that you will, to the utmost of your ability, keep the persons sworn as jurors on this trial from separating from each other, that you will not suffer any communications to be made to them or any of them orally or otherwise, that you will not communicate with them or any of them orally or otherwise except by the order of this court, or ask them if they have agreed upon their verdict until they shall be discharged, and you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed, so help you God?
I swear.
All right, put your hand down. All right, with that, ladies and gentlemen, I will have you go ahead and follow Mr. Weaver to the jury room. If you need the exhibits and say so, we will give you the verdict form and the instructions here in just a moment. You may be seated. All right, should reflect the jury's down in the jury room. Anything before you have, Mr. Roberts, do you have all the exhibits collected?
I do have the exhibits collected, and I actually do have a statement as it relates to one of those, the final exhibit that we marked, and we had a discussion about it being admitted, and certainly it was by stipulation, but, and I believe now we are just going to stipulate that number 45, that was the recording that was made,
okay.
was admitted.
Okay.
Otherwise, yes, all the exhibits.
Mr. Johnson, any objections there?
I do not have an objection to that.
Okay, we actually have a laptop that they are allowed to use, so I guess sometimes I just send in the exhibits to kind of save time, but any objection to just simply doing that?
I would prefer, yes.
Okay.
That
so
was on a flash drive.
Oh, okay. All right, so what we'll do is we'll simply send in the exhibits as well as our laptop, which prevents them from accessing the internet and all that.
Do we want them to sit in a hot sauce? You actually? Unless they ask
There
for
are a
them.
couple of the other physical exhibits are actually in Mr. Weaver's office, I believe. Anyway, so
Yeah, I mean,
we can keep them.
it's not a weapon. I mean, typically I'm concerned about weapons or drugs, but.
From the description, I'm not sure that's accurate. but-
Yeah, yeah. I don't have an objection to it unless somebody has some serious objection. They seem like pretty responsible people not to start tampering with stuff.
Sure,
So Mr. Weaver could maybe just suggest they not take it out of bags or anything. Can you do that?
Okay.
Okay. All right. Anything else for the record, Mr. Roberts?
No, Judge, thank you.
Mr. Johnson?
No, sir, and thank you.
You're welcome. Thank you, gentlemen. All right, just kind of stay in the area in case we have an early question, so.
Yes, sir.
All right.
Any jury instructions?
Yeah, I have them given to you. Actually, here, if you want to.
Donald Trump is not what you would call a model Christian. He is not into asking for God's forgiveness. He could not name a single verse, any verse, when asked for his favorite Bible passage. He has openly mocked conservative religious leaders. But beyond his handing of the Supreme Court over to hardline conservatives, evangelical
Okay, this court has sat through the trial. has heard arguments of defense and the state, has listened to the witnesses today, and after considering all of those things, the court will impose sentence as follows. Please stand, Ms. Payne. With respect to count 1, malice murder, the court will impose a sentence of life with a possibility of parole. With respect to count 2, felony murder, that will merge into count 1 and is dismissed as a matter of law. With respect to count 3, aggravated assault, that merges into counts 1 and 2. With respect to count 4, felony murder, that merges into count 1 and it is dismissed as a matter of law. With respect to count 5, the false imprisonment verdict, the court imposes a sentence of 8 years consecutive. With respect to count 6, possession of a firearm during the commission of a felony, the court imposes a sentence of 5 years that will run consecutive to the underlying sentence. Count 7 and 8 will merge into count 6. So the court's total sentence is life with the possibility of parole plus 8 years consecutive on the false imprisonment and 5 years consecutive on the possession of firearm during the commission of a felony. And that is the court sentence. So I'll remand you again, Ms. Payne, into the custody of the Sheriff's Department.
We need to notify the defendant.
Before I do have some instructions for you, Ms. Payne. You have a right to seek post-judgment relief from your conviction of the crimes, either by making a motion for a new trial in this court and or filing an appeal to a higher appellate court. If you want to file a motion for new trial or an appeal, then you will need to file the said motion or a notice of appeal with the clerk of Superior Court of this county within 30 days. You may want to more fully discuss this with your attorney. If a motion for new trial is made and the court denies it, you will have 30 days from the filing of this order of denial in which to file with the clerk of court your notice of appeal. You have a right to have an attorney represent you on the motion for new trial and the first level of direct appellate review. And if you cannot afford to hire an attorney, the court will provide you an attorney and a transcript of your trial at no cost. In addition, usually you have a period of 4 years from the date of your sentence, which is today, before in this court becomes final to file a habeas corpus petition. The details that can affect the time within which you must file this petition are contained in the copy of this code subsection, and I'm going to ask the deputies to hand that to you. And so you have 4 years from today's date to file a habeas corpus petition. Councils, I can confer with you as to set in a date for the hearing for a motion for new trial, but we can do that once we're adjourned. Okay. Deputy, could you have that?
I just have one question after the name.
Yes.
I noticed you said 8 and 5. Are any of those additional charges or any of that going to be probated?
I believe I was very clear, Attorney Tucker, that they're consecutive.
So it's consecutive to serve?
The life with the possibility of parole. Okay. Anything further from the state?
Nothing further from the state, Judge.
Anything further from defense counsel?
Further from the defendant.
Okay, thank you. Ms. Payne, you may go with the deputies at this time. With respect to this matter, the court stands adjourned at this time.
I go into my reasons for the sentences that I'm about to impose, I want to address two things. First, the defendant's suggestion that the Concord police somehow engaged in an effort to wrongfully convict him. I think the words that he used were something along the lines of to throw sand in the eyes of the people in an effort to do so. Let me be clear. There is absolutely no basis to that claim. Having sat through the trial in this case and the pretrial proceedings, there is no doubt in my mind the Concord police worked tirelessly and skillfully to bring the killer of Stephen and Wendy Reed to justice. They developed leads, they carefully considered evidence, and they put together all the evidence in this case demonstrating beyond a reasonable doubt. This wasn't just the Concord police. A jury of 12 people found that the defendant committed these murders. The suggestion that somehow his conviction in this case is the product of misconduct by the police is insulting, it's outrageous, and it's untrue. Nothing else reveals the sort of person who stands before me to make such a claim when the evidence suggests completely to the contrary. Let me address the family of Stephen and Wendy Reed. In my view, the most important people who are here today. Those were very powerful statements delivered in court and also provided to me in writing. I read each of them and I listened carefully to all of you. I appreciate those words because they gave me a sense of who your parents were, who your brother was, who your family friend was, and I feel like I don't know them, but I have a sense of who they are, and I have a sense of what their absence means to each of you, not having them with you. Thought a lot about them in the months leading up to this trial and before today, and to have a clearer picture of not just the pictures that we saw of them in those woods, but the lives they lived and the difference they made to each of you is very powerful. Whenever I consider punishment, sentencing rather, I consider the purposes of sentencing. Punishment, general and specific deterrence, and rehabilitation. I've thought a lot about each of those here leading up to today and this morning. The arguments of counsel, statements by the victim's family, the defendant's prior background, and I want to be clear that as far as that's concerned, I'm not going to consider anything that did not result in a prior conviction of Mr. Clegg. There was some reference to a prior stabbing. It's my understanding that that did not result in a conviction. That's not going to be part of the sentences that I'm imposing today. Most importantly, I think about the circumstances surrounding the crimes themselves. The defendant has been convicted by a jury of the murders of Stephen and Wendy Reed, falsifying physical evidence and being a felon in possession of a handgun. As I said earlier, I listened carefully in the course of the trial to the testimony of witnesses, and I considered the evidence that was presented in the course of the trial. I've spent a lot of time thinking about this case before, during, and after trial. What makes this case so hard to comprehend, and some of the victim statements referenced that earlier today, is the question that may never be answered. Why? I don't have an answer for any of you today, and as I said, we may never have an answer to that question. But as I think about the appropriate sentences in this case for Mr. Clegg, there are some things that are clear. On the afternoon of April 18th, 2022, Stephen and Wendy Reed left their home and went for a walk. They went on a trail in the woods, a place many people from Concord go to mountain bike, walk their dogs, to hike, a place of peace. Shortly after they entered the woods, they encountered the defendant, by all accounts a total stranger to them before that day. For some incomprehensible reason, he pulled out his 9mm semi-automatic handgun and shot them multiple times, killing them. There's no question he had a 9mm handgun. The evidence came in about his purchase of that gun, and he was found with that gun when he was arrested in Vermont. As I think about this case, though, I've thought a lot about what Stephen and Wendy must have felt when the defendant pulled out that gun and started firing on them. No reason, no justification, the senseless, horrific murder of two innocent people. But what most of those moments have been like for them? Talking to each other, observed by a witness, entering the woods, having a normal conversation, and minutes later to have somebody pull a handgun and open fire on them. People who devoted their lives to each other, their family, and helping to make the world a better place. Violently shot by the defendant seconds after they encountered him. The defendant wasted no time hiding their bodies and trying to cover up his actions. He burned his nearby tent site, which included almost all of his worldly possessions, and fled conquered. He took steps to fly under the radar, hoping he would escape the consequences of his actions. Bought a ticket to Germany, a false Romanian passport, and amassed savings to get away. Those are not the actions of somebody trying to escape a probation violation. Those are the actions of a murderer in flight from his conduct. The question of sentencing in any case is hard. Most people who are sentenced will re-enter society at some point. The hope is that they will emerge from their punishment and their time in custody, rehabilitated and less likely to offend. For some people, however, who commit acts so senseless, so violent, and so terrible, the sentence needs to be crafted in a manner to make sure that they can never be in a position to hurt another innocent person. From my perspective, this is such a case. Any rehabilitation of the defendant should occur when he is safely in the four walls of the prison. Stephen and Wendy Reed were good people. They should have been able to enjoy their retirement together, their children, their family, and their friends. Go on many hikes together. They should have been able to do that. Logan Clegg is a stone-cold, violent murderer, nothing more. He shot and killed Stephen and Wendy Reed for no reason. His statements today ring hollow. He deserves nothing less than a sentence that fully reflects the magnitude of his crimes, and for that reason, I'm going to fully impose the sentences as recommended by the state. On charge ID 202-7584, a finding of guilty is entered. The defendant is sentenced to New Hampshire State Prison for not more than life, nor less than 50 years. There is added to the minimum sentence a disciplinary period equal to 150 days for each year of the minimum term of the defendant's sentence to be prorated for any part of the year. He has pretrial confinement credit of 422 days. This sentence is stand committed commencing today. He shall pay restitution of $17,564.39, $3,878.08 to Lindsay Reed, $13,686.31 to the Victims' Compensation Fund. I know, given the sentences that I've imposed and his circumstances, that he has no ability to pay counsel fees and expenses. That order throughout for the rest of his life. He is to participate meaningfully in and complete any counseling, treatment, and educational programs as directed by the Correctional Authority or Probation Parole Officer. The Department of Correction shall have the authority to award him earned time reductions against the minimum and maximum sentences for successful completion of programming while incarcerated. Law enforcement agencies may destroy the evidence and return it to its rightful owner. The defendant is ordered to be of good behavior and comply with all terms of the sentence. On charge ID 202-7585, finding is guilty is is entered on that charge of second-degree murder. Defendant is sentenced to New Hampshire State Prison for not more than life nor less than 50 years. There is added to the minimum sentence of disciplinary period equal to 150 days for each year of the minimum term of the defendant's sentence to be prorated for any part of the year. The sentence is to be served as follows. Stand committed. The sentence is consecutive to the sentence that I just read. Again, no responsibility for counsel fees. Defendant counsel fees in programs as directed by the correctional authority or probation parole officer. Subject to the provisions of RSA 651A, the Department of Corrections shall have the authority to award him earned time reductions against the minimum maximum sentences for successful completion of programs while incarcerated. I truly hope he engages in rehabilitation, but there's no chance, if this sentence holds, that he will spend a day outside of the prison. Law enforcement agencies may destroy the evidence, or return it to its rightful owner. He's ordered to be of good behavior and comply with all terms of the sentence. The remaining charges in charge of D 2091545 for falsifying physical evidence, 2053093 for falsifying physical evidence, 2053094 for falsifying physical evidence, 2053095C for falsifying and 2053096 for being a convicted felon in possession of a dangerous weapon. These sentences are identical and concurrent to the second consecutive life sentence, 50-year to life sentence that I've just imposed. Each of these sentences is as follows. The defendant is sentenced to New Hampshire State Prison for not more than 7 years, no less than 3.5 years. There is added to the minimum sentence disciplinary period equal to 150 days for each year of the minimum term of the defendant's sentence to be prorated for a part of the year. The sentence will be served as follows. Stand committed, consecutive. Again, these are all concurrent with each other and consecutive to the first sentence and concurrent with the second 50 to life sentence. Again, for each of these, no responsibility for counsel fees. Again, these are participating immediately in counseling, treatment, and educational programs as directed by the correctional authority. The parole officer, the Department of Corrections shall have the authority to award him earned time reductions against the minimum maximum sentences for successful completion of programming while incarcerated. Law enforcement agencies may destroy the evidence or return it to its rightful owner. He's ordered to be of good behavior and comply with all terms of the sentence. Again, these are all identical and concurrent to each other. It is my hope in imposing these sentences that the defendant never again walks the streets as a free man and that no one else has to suffer the same fate as he is going to be. I hope that the family has peace. I wish you all the best. And that concludes the sentencing hearing. Thank you.
Rise to court.
Your Honor,
Yes.
may I make one request?
Yes.
With regard to restitution, that it be held in abeyance pending here, however, to the Victim Compensation Fund. I believe that there's $3,895 that's in.
So, Your Honor, the state had requested that the total amount of restitution be determined within 30 days. We submitted an updated form yesterday, I believe, so the form you may have read off with regard to the total amount of restitution was incorrect.
Okay.
However, the form that would have been submitted yesterday would have indicated that the total be determined within 30 days. There was $13,686.31 to victims' comp, which was reflected in that original sentence, but the amount to Lindsay Reed was inaccurate. So the state is asking some additional time to be able to come up with that total amount.
So in terms of this request that be held in abeyance until after the appeals, I think practically no money's going to change hands in the next 30 days. We
Agreed.
all recognize that. Any objection to that?
No, Judge.
Okay, I'll make it clear that.
Thank you, Judge.
Or is it recessed?
But the jury has to make that decision as to what the outcome will be, convicted or not. They've been deliberating 21 minutes. We're going to take a break. When we come back, you will see the remainder of the state's rebuttal. Stay tuned.
Tonight on Closing Arguments, all the evidence is in the tortured son murder trial. Did defendant Shanda Vander Ark's testimony help or hurt her case in the eyes of this jury?
Isn't it true? Timothy had just become nothing more than an annoyance for you. He wasn't even a human being in your eyes anymore.
That is absolutely not true.
We'll bring in experts to weigh in on every pivotal moment as this trial reaches its end.
Closing Arguments, tonight at 8/7 Central, only on Court TV.
Free Movie Channel has something for everyone. With no subscription or rental fees, Free Movie Channel is the quick and easy choice for first-run films, as well as classic movies. Check out Free Movie Channel today and find your new favorite movie.
When people drop into the American Place Casino, you won't believe the things they say.
It looks amazing in here.
Pretty cool, right?
I'm gonna go play some blackjack.
Oh, I'm hitting the slots. With the most exciting table games and newest slots, you can play any way you want. Oh, and the food.
So good.
So what are you waiting for? Come in now and have an experience that'll make you say, couldn't have said it better myself. American Place Casino. Change the game.
Los ahorros en Arlington Toyota están más grandes que nunca. Puedes explorar los nuevos Toyotas o aprovechar las increíbles ofertas en su gran inventario de carros usados, como financiamiento de 3.9% por 72 meses, además de incluir 2 años de mantenimiento en autos certificados selectos y 56 bahías de servicio y técnicos especializados. Siempre habrá un espacio para cuidar de tu auto. Aprovecha los grandes ahorros en Arlington Toyota y sal manejando a casa hoy mismo.
Weeknights.
Daddy and I have some exciting news.
Laugh More has a new man of the house.
Sounds like a plan that makes everybody happy.
And he runs a pretty tight ship.
You got blackjack. That pays 3 cookies to 2. I have responsibilities.
My game starts in 20 minutes.
You said having kids would be fun.
I said making kids would be fun.
Man with a plan. Weeknights starting at 11/10 Central on Laugh More.
Are you laughing at me?
So hard.
Let the games begin.
Let's get some more. Oh, okay.
I got to get my dance on.
Hey, family. I'm coming back to this show. Isn't this just fabulous?
This is Israel at war. Our special coverage is from Tel Aviv to Washington.
These are really mounting of a wider escalation. The army is evacuating the press with urgency.
Jason Bellini, he's live in southern Israel right now.
Behind me, Israeli forces are firing upon Gaza. You can still see the shell casings on the ground from what was clearly an intense firefight.
We continue to stay on top of the latest developments out of Israel.
Israel at war. For continuing coverage, stay with Scripps News.
He's a coyote. He works for the cartel. Without a border, you don't have a country.
These men can be out there running around with their guns. I thought that we had laws against vigilantism.
Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you put your hand down, grab a seat. Please state your name for the record, spelling your first name and last name.
Paul Ferguson, Paul Ferguson.
Mr. Ferguson, you are testifying here today, and is it your understanding that you do have an agreement with the Muskegon County Prosecutor's Office in exchange for your testimony today against your mother, the defendant in this case, Shanda Vander Ark?
Yes, sir.
And is it your understanding that as part of that agreement, the people have agreed that none of your testimony today would be used against you should you exercise your right to have a trial in the pending criminal matter against you?
Yes, sir.
And is it also your understanding that in exchange for your testimony today, you understand that the prosecutor's office will make representations to the judge that oversees your case if such time is reached that you are sentenced in that matter, and that you hope to get some sentencing benefit as a result of your testimony today?
Yes, sir.
And is that in exchange for your truthful testimony today?
Yes, sir.
Are you aware of any other promises in regards to your testimony today?
No, sir.
And and for clarity's sake, you are also charged in this matter involving the death of your brother. Is that correct?
Yes, sir.
And what charges it brought against you at this point?
Child abuse, first degree.
And what do you understand the potential maximum penalty for? Well, you know what? Strike that. I won't ask that question. And you are prepared to testify today. Is that correct?
Yes, sir.
And you understand that your attorney that represents you in your pending criminal matter is present in the courtroom. That's Mr. Eldon Brady. And if at any time you need to ask him any questions or take a break, you just let us know. Okay?
Yes, sir.
All right. Okay, Mr. Ferguson, I'd like to start by just talking a little bit about your home in Norton Shores at the time that your brother passed away. And so you understand, and I'll try to make sure that I ask these questions very carefully because you haven't been present for this entire trial. You have a younger brother. We are not using your younger brother's name today, okay? So we're just going to use the initial G when we talk about your younger brother. So try to remember as best you can that if I ask a question that somehow involves your younger brother, that we're not going to say his name, okay? Can you do that?
Yes, sir.
All right. We'll try to ask those questions very carefully so that we don't get into that issue. But besides your younger brother, G, and yourself, at the time that your brother Timothy Ferguson passed away, who was living at the house in Norton Shores? Besides you and your younger brother, who else was living in the house?
My mother and my little brother, though he was at my grandparents at the time, my step-grandparents.
And obviously your younger brother, if you can put it that way, but your youngest brother is the one that we're not identifying by name. He was living in the house at the time that your next youngest brother, Timothy Ferguson, passed away, correct?
Yes, sir.
And your mother was also living in that house as well?
Yes.
And is she in the courtroom right now?
Yes, sir.
As best you can you kind of point her out or maybe say what she's wearing right now?
Her hair is in 2 braids. She's got, I think that's a black sweatshirt.
I think that's sufficient for the record to reflect the witnesses identified the defendant, Your Honor.
Yeah, the record reflect that.
Now let's back up just a little bit from the time your brother Timothy actually passed away. When did Timothy come to live with you and your mother in that house?
May 27th of 2001.
2001. Was it maybe 2021?
21.
Okay.
I'm so sorry.
That's okay. That's okay. So in May of 2021, Timothy came to live with you, is that right?
Yes, sir.
And at the time when Timothy came to live with you, besides yourself and G, was there somebody else that was living in the house during that time period?
Other than my mother and half-brother, my stepfather, Adam.
Okay. And your stepfather, Adam, was he married to your mother at that time?
Yes.
And is he actually the father of your younger brother, G?
No.
But your mother is the mother to you and to Timothy and to G, is that right? She's your mother, she's Timothy's mother, she's G's mother, is a better way to put it.
Yes.
Right? Yes. Okay. And at some point in time, did something happen to Adam where he wasn't living in the home anymore?
He suffered a stroke in January.
Did he leave the house at that point?
Yes.
When he left the house at that point, then is that then when it became just you, your 2 brothers and your mother living in the home?
Yes, sir.
And when Adam suffered the stroke, was he physically able to do anything to provide any care to either you or to Timothy or to G?
No.
And where did Adam go when he left the house after the stroke?
After the hospital, he went to live with my step-grandparents, my in-laws, in their house in West Olive.
When did the stroke happen?
January.
And from the time the stroke happened, was he ever back in the home in any way?
No.
And the folks that he went to live with were his parents, is that right?
Yes.
And they live in West Olive, down in Ottawa County?
Yeah.
So those would be like your step-grandparents?
Yes.
And they'd be Timothy's step-grandparents as well, is that right?
Yes.
Now, in addition to your younger brothers that we've talked about, do you have any older siblings as well?
Yes.
Who are your older siblings?
My biological brother, Nolan, stepsister, Chelsea, stepbrother, Chris. There's, I don't know exactly how to put it, step brother and sister, Kenzie and Xavier, I suppose would be the terminology.
But biologically speaking, you have an older brother, Nolan, is that
Yes.
correct? And Nolan is how much older than you?
2 years.
2 years older than you.
Yes.
And was there ever a time where he lived with you at the house in Norton Shores?
No.
Where does Nolan live?
North Carolina.
So Timothy came to live with you, and prior to Timothy coming to live with you, was it just you and G and your mom and stepdad in the house at that time?
Yes.
So you went from 4 people in the house to 5 people in the house in May of 2021?
Yes.
And then back down to 4 people when Adam unfortunately had his stroke in January of 2022?
Yes.
Now, around shortly after the time of the stroke, did there come a point in time where you became involved in having to administer some discipline to your younger brother, to Timothy?
Yes.
We'll talk about some specifics, but we've already had some text messages read, and you've had an opportunity to kind of hear about some of those text messages throughout this, right?
Yes, sir.
And you sent text messages back and forth between yourself and your mother. And we have those text messages from January through the time of your brother's death in July of 2022. Is that your understanding?
Yes, sir.
At some point in time in February, there's a discussion fairly early in those text messages about blocking Timothy's access to food. Can you describe what was happening at that time and how he was restricted from getting access to food?
He was sneaking food that was not necessary at that time, and it was solved by placing locks on the fridge, freezer, and pantry.
And when you say he was sneaking food that wasn't necessary, who would make that determination that it wasn't necessary?
Shanda.
And what type of food are we talking about that he would sneak that wasn't necessary?
Sweets or anything he could really get his hands on.
So as early as February, there was restriction, the locks were going on the freezer and the refrigerator, and you said there was also some type of lock on the pantry, is that right?
Yes, sir.
And we've heard a text exchange, but at some point a little bit later, as things are progressing into April, was there a time where Timothy was doing something to get the locks off of the pantry door?
He was pulling them off by hand.
And what were you instructed to do as a result of him pulling the pantry door locks off? Let me ask you this way: were you given some instruction to replace that lock?
Yes.
And who gave you that instruction?
Shanda.
And what was your understanding of why you were locking the pantry back up?
Because he was sneaking food.
Let's talk about your brother Timothy for just a little bit. Did Timothy have some special needs?
Yes.
What was your understanding of what his special needs were?
He was attention deficit hyperactive disorder, as well as autistic. He had speech and motor impairments.
Speech and what type of impairments?
Motor impairments, movement impairments.
Movement impairments?
Yes.
And at the time that he came to live with you, was he supposed to be taking some medication?
Yes.
And did he stop taking his medication?
Yes.
Why did he stop taking his medication?
Could you please reiterate?
Yeah, I guess the better way of saying it is, who made the decision for him to stop taking his medication?
Shanda.
As far as you know, from the time that Timothy came to live with you in May of 2021 in Norton Shores to the time of his death, did you ever see Timothy go to a doctor?
No.
Did Timothy go to school?
Not public, no.
How was he schooled?
Home.
When we say homeschool, what would that entail?
At first it was assignments on a tablet, and then my mother restricted it to where she would print out the assignments and he would sit downstairs and do them.
So he never went to school and never went to a doctor, as far as you could see?
Yes, sir.
Basically from January, from the time of the stroke moving forward, was Timothy allowed to even leave the house?
No.
When, if ever, was he ever allowed to go outside?
To walk the dogs sometimes.
And when he would walk the dogs, where was it that he would walk the dogs?
In the backyard, out of sight.
Was there ever some physical discipline that was involved with him being outside as well?
Yes.
What was that discipline?
He was made to run up and down the patio stairs.
And those are stairs in the back of your house?
Yes, sir.
Are those visible at all from the front of the house?
No, sir.
Visible to anyone walking by on the street or driving by, anything of that nature?
No, sir.
There are some text messages referenced in there where there's a discussion about doing the stairs chasing style. What is that, if you remember?
Following close behind him to ensure he moves faster.
And who would be the one that would chase him if that was taking place?
I had to.
What was, besides, you've talked about some of the special needs that Timothy had when he came to live with you. What was his overall physical appearance, though, when he first came to live with you?
He wasn't skinny, but he wasn't extremely overweight. He had a good amount of chubbiness to him.
So he was a little chubby?
Yes.
Obviously, as we all know, and now the jury's already seen some of the photographs, that went away at some point in time. When did the food restriction on Timothy start, with the locks going on the refrigerator, the freezer, and the pantry, and things of that nature? When did that actually begin?
Sometime in February.
There's been some testimony already about Timothy going on a hunger strike around the time of Adam's stroke. To your knowledge, did Timothy ever go on a hunger strike when Adam had his stroke?
No, sir.
There's also a reference to him going on another hunger strike about 2 weeks before he passed away. Excuse me, did that happen?
No, sir.
The police have indicated at the time they searched your residence, there were a number of cameras seized, as well as some other items. So let's talk about the cameras first. What was the purpose of the cameras being inside the residence?
To watch Timothy.
And who would be watching Timothy on those cameras?
My mother, or when she couldn't, she had me do so.
And how is it that you would, kind of explain for the jury if you can, how is it that you watched the cameras so you could watch what Timothy was doing?
I would log into the app on my phone, and it would alert me if there was a motion movement.
So you had some type of, you had your phone and you had some type of app on there that was connected to those cameras?
Several, yes.
And you said that you were also alerted to movement. Were there motion sensors in the home?
Yes, and the cameras also had that feature as well. They activated on motion.
And what was the restriction on Timothy's movement that would cause those cameras to go off? Where was he limited to?
Could you please reiterate?
Yeah. Where is it that, where could Timothy go, basically?
Mainly he was restricted to the downstairs area, to a closet downstairs.
The downstairs area actually contained 2 bedrooms. One was yours and one was G's bedroom, is that correct?
Yes, sir.
And there was also a bunk bed that was out in that area that I believe that the defendant indicated was Timothy's bunk bed, is that correct?
Yes, sir.
Where did he actually sleep most nights?
In the closet.
And what did you call the closet? Was there a name you used to refer to the closet?
The small room.
And what was in the small room if Timothy was in the small room?
There was a camera monitoring him, even when he slept.
Was there an alarm on the door as well?
Yes, sir.
Some type of motion sensor or alarm?
Motion, vibration, yes.
So we had that on the door and then a camera actually inside the room as well, is that correct?
Yes, sir.
And were there times where you were required to watch that camera?
Yes, sir.
And to your knowledge, were there times when your mother was watching that camera as well?
Yes, sir.
Was there a restriction on how much Timothy could move while he was inside that closet?
Could you please reiterate, sir?
Were there any restrictions on his movement inside the closet, or was it he could move around however he wanted inside the closet?
There were restrictions.
What were the restrictions on his movement?
Hands on his head, normally.
Hands on his head, is that what you indicated?
Yes.
Was that some form of discipline for him?
Yes, on his knees and against a corner or wall of the room.
And when you say hands on head, I'm going to demonstrate just putting my hands just over my head like this. Is that what he was required to do?
Yes.
He was required to be on his knees as well? Say yes?
Yes, sir.
You have to say yes or no, because this is
I
being
apologize.
recorded. You're fine. No, it's fine. Everybody makes that mistake. It's not a And was he monitored to make sure that he was doing those things?
Yes, sir.
And for how long would he have to do these things?
Several hours.
And that was inside his closet, for lack of a better way of putting it, what you referred to as the small room, correct?
Yes, sir.
Were there also times when he was required to stand against the wall?
Yes, sir.
And would that be in the closet, or would that be in other places in the house?
At times it would be upstairs by the back door or on the wall between me and G's room.
And when he would stand against the wall, how long were we talking about that he would be required to do that?
Hours, sometimes overnight.
At some point, did you utilize some type of alarm or alarms on his body to alert you if he was moving?
A vibration detector, yes.
Was there more than one that he was required to wear at times?
At times, yes.
Where were those devices located on his body?
They were normally tied to the back loop of his belt, or the back loop of his pants, I apologize.
And was there something placed on his wrist as well at any point?
Handcuffs, and before that, zip ties, zip cuffs.
When you say zip cuffs, are those put together with zip ties?
Yes.
And those were designed to restrict what?
Movement.
Of what part of his body?
His hands.
I think there's a text exchange that the jury's heard a couple of times where it's referencing him tightening those zip cuffs on his wrist. Do you recall that?
Yes, sir.
And so what was happening that caused you to send that text message and had that exchange with your mother about those zip cuffs?
He was complaining about them being too tight.
And what was your mother's response when he was complaining about those being too tight?
To leave them and she'd deal with it after she got home.
So the jury has some clarity in terms of a schedule here. You and your mother worked basically different shifts, for lack of a better way of putting it. Is that fair to say?
Yes, sir.
What was your job at that time?
I worked as a dishwasher at Applebee's.
And was that, which Applebee's?
The one in Grand Haven right off the bridge.
What was your normal shift that you would work?
4 to close.
What, at that time, was your mother working as well?
Could you reiterate?
Did your mother have a job as well?
Yes.
Where was your mother working?
As a court scribe, I believe you would call it.
Okay, and where physically was that job?
Did I remember of? Did she say here at this courthouse?
So there was a time she worked at the Muskegon County Courthouse?
Yes.
Do you remember a time when she worked in a northern county at a courthouse as well?
I believe so, yes.
And what was her normal hours that she would work?
6 a.m. to 6 p.m.
So would it be fair to say that you two are not together in the house very often?
Yes.
So whose responsibility was it to keep an eye on Timothy if she was not in the house?
Mine.
And vice versa, like if you were not in the home, who would take the responsibility of watching Timothy at that point in time?
She would.
At the small room that you've described, at some point in time, there was a tarp placed in there, is that right?
Yes, sir.
And what was the reason there was a tarp placed in that room?
Due to Timothy's bladder problems, Shanda didn't want him urinating on the floor.
Would that be something that he would do?
Yes.
Did he wear some type of adult diaper?
Adult diaper, yes.
And let me ask it this way. If Timothy had to go to the bathroom, how would he go to the bathroom?
He would have to ask and he would be timed.
And who would do the timing?
Whichever one of us was there.
So he'd basically has to ask permission to go to the bathroom?
Yes, sir.
And what time was he allowed to go to the bathroom?
For urinating, it was a minute. For
You can say the word, it's okay.
Taking a poop, it was 2 minutes.
And who set those time limits?
Shanda.
We've seen a lot of text messages and references to hot sauce and hot sauce retrieved from the home. At some point in time, were you asked to start feeding him bread with hot sauce on it?
Yes.
And who asked you to do that?
Shanda.
Why were you giving him bread with hot sauce on it?
Because he was supposedly misbehaving.
And how would you, describe to the jury what you would do to do that and to make him eat the bread with hot sauce?
I would put it on bread, have him stand in the kitchen area near the back door and watch him eat until he finished.
And was he required to eat it until it was all gone?
Yes, sir.
Did it ever look like he wanted to eat the bread with hot sauce?
No.
Were there times where you were told that he could have something besides bread with hot sauce on it if he ate the bread with hot sauce first?
Regular bread, yes.
So he had to eat that bread with hot sauce first, and then he could have some regular bread?
Yes.
Did he have to wait a period of time before he could eat the regular bread, though?
Yes, sir.
Do you remember about what that was, about how long?
30 minutes.
With taking out the bread out of the equation, was hot sauce used in some other fashion as a form of discipline for him?
It was poured directly into his mouth.
And who would do that?
Me or Shanda, me under her orders.
And it's just like what you sound like? How did you do that?
Had him open his mouth and poured it in.
There's some text messages. Do you recall a text message exchange with your mother in, I believe it's around April or so, where you've alerted her to the fact that he's eaten some part of a burger?
Yes.
Do you recall that?
Yes.
What was it? What part of the burger is it that he ate?
Just the crust.
And what was your mother's response when you told her that he had eaten the crust of that burger?
Make him throw it up.
Did you try to do that?
I tried at first, yes.
How did you try to do that?
Putting a finger into his mouth as instructed to the back of his throat to induce vomiting.
So who gave you the instruction to put your finger in the back of his throat?
Shanda.
We don't see a text message to that effect. Were you two also communicating by camera as well?
Yes.
The cameras had was it a two-way capability, basically? You
Yes.
could talk to the camera or
You
something
could
on the
talk
camera?
and they could hear. At certain times, it could be activated.
Was there ever any other time where she instructed you to make Timothy throw up?
Yes.
About how many times did she instruct you to do that?
3 or 4.
At some point in time, was there a form of discipline introduced that involved you placing Timothy in a cold tub?
Yes.
And what was the mechanism for that? How did you do that?
Clog the tub, plug it, turn on the water, and take the ice that was in our ice maker upstairs and put it in, and have him get in.
Initially, how long was he supposed to sit in the cold water?
30 minutes.
30 minutes? And that, when we say cold water, we actually mean water with ice cubes in it? Is that what you're talking about?
Yes.
And how often, when did that start in relation to when Timothy died, if you remember?
I do not remember the exacts.
And do you know about how many times you did that up until the day the day before Timothy died?
Before the day that Timothy died?
The day before Timothy died, we'll get to that in just a moment, and I believe that...
3, then.
So you remember doing it 3 times before the day before Timothy died?
Yes.
And who would direct you to put him in the ice bath?
Shanda.
Was there some type of camera in the bathroom as well?
Yes, on the counter.
Was that camera monitored by somebody if you were in the bathtub, or if you were in the bathroom with Timothy?
Shanda.
Were you instructed to stay in the bathroom with Timothy when he was in the tub?
Yes.
Why?
To ensure that he couldn't get comfortable or try to turn the water hot.
And what would you, if you tried to move around, what were you instructed to do?
I don't quite understand.
If you said that you were supposed to make sure that he stayed uncomfortable, how were you supposed to make him uncomfortable in an ice bath?
Put his body at an odd angle that was not a comfortable position to be in.
When he was in the tub, would he try to rest his head somewhere?
On his shoulder, yes, or the lip of the tub.
Was that allowed?
No.
I know this is difficult for you, Paul, and you and I have had a number of conversations about this matter. But I need you to look at a text message that you sent to your mother. It's got a photo that you took of your brother. You remember sending that text message?
Yes, sir.
For the record, this is People's 36A. This has been previously shown to the jury. Who took that photo of your brother?
Me.
And you sent it to your mother?
Yes, sir.
Why did you send it to your mother?
Because I was concerned with how thin he was.
And that photo was taken on, do you remember what the date was?
Not the exact, no.
If your phone indicated it was June 13th, you'd have no reason to dispute that.
No, sir.
And you just became, again, the reason you sent it to your mother was why?
Because I was concerned about how thin he was.
Do you remember what your mother told you to give him after you sent her that photograph?
Bread.
And then is there a reference to bread and some peanut butter?
Yes.
So at that point, your brother's very skinny, right? Was he eating regular meals at that point?
No.
Were you still administering the hot sauce on the bread as a form of punishment for him during that time period?
Yes.
And did that continue all the way up until the time of his death?
Yes.
Did he ever eat any normal type of meal leading up to his death after you took that photo and sent it to your mother?
That day I made him an actual real meal, an actual peanut butter and jelly sandwich, as well as scrambled some eggs and put cheese in them.
Did you tell your mother you had made that meal for him?
No, sir.
Why not?
Because I didn't want her to be upset with me.
Let's move up to the day before your brother passed away. Do you remember the day before your brother died?
He was unresponsive when I was told to get him up.
So you were given some instructions to wake him up in the morning?
Yes.
Was your mother already at work?
Yes.
Were the cameras activated at that point, though?
Yes.
So your responsibility when you had to go wake him up was what? Just to do what? To get him up?
Just wake him up, which normally wasn't difficult before then.
And this is the day before he passed away, but was it difficult on that day?
Very.
Did you scream at him and yell at him to get him to try to wake up?
Yes.
And at some point were you instructed to do something with him because he wouldn't wake up?
Put him in an ice bath.
And did you do that?
Yes.
Was he able to, where was he sleeping that night?
Closet.
So when you went to wake him up and he was unresponsive, was he still in the closet?
Yes.
How did you get him from the closet to the bathroom with the
I
ice
had
bath?
to drag him.
He didn't stand on his own?
He couldn't, no.
Didn't walk on his own? Is that enough? Is that
No.
enough? Was he even talking at that point?
No.
Do you remember about what time it was that you put him in the ice bath?
Not exactly, no.
If the text message indicated was around 2 o'clock, does that sound about right?
Yes.
What time did you have to leave for work that particular day?
I was supposed to be at work at 4, but unfortunately, due to a flat tire on my e-bike, I had to wait till 6 for my mother to get home and drive me to work.
So from 2 to 6 until your mother got home, you were home with Timothy, is that right?
Yes,
And where was Timothy that entire time that you were home with him?
in the bath.
In the ice bath? Was your
Yes.
mother giving you instructions on what to do with him while he was in that tub then, at that point in time?
Yes, sir.
What was she telling you to do?
Make him uncomfortable, and at one point she had me heat up a pizza roll to see if he would be responsive to enticement.
Did you actually do that?
Yes.
And what did you, so describe for the jury exactly what you did with that pizza roll with Timothy in the tub.
I held it close, and when he responded, as per instruction, I was to pull it away from him.
So did you actually do this?
Yes.
So you actually held a pizza roll in front of him to see if he would respond? Is that yes?
Yes, sir.
I know it's difficult. Did he respond?
Yes, sir.
And what did you do when he tried to respond?
I had to, or as I was told, I pulled it away.
So we didn't get to eat the pizza roll?
No.
Do you recall, while Timothy was in the tub, an exchange where your mother inquired about pouring hot sauce on his private parts?
I do, yes.
Did you do that?
No. That was beyond rule, as everything else was.
So you put him in the tub around 2. Did your mom come home at 6?
Yes.
And when your mom gets home at 6, did you go to work at that point in time?
She drove me to work, yes.
And was Timothy still in the tub at that point in time?
Yes.
So you and your mom drove to Grand Haven to drop you off at work, and Timothy's just in the tub?
Yes, sir.
Was he even physically able to move around at that point in time?
No.
Do you recall getting a text message from your mother around 11:30 or so that night while you were at work?
Yes.
And
Though I saw it later than that because I was busy.
so you received the text message, but you didn't actually read it until a little bit later than it was received.
Yes, sir.
And what did you understand from that text message from your mother about where Timothy had been up until the time you were at work at 11:30 at night?
Still in the tub.
So that's 9 hours plus from the time that you first put him in the tub at 2 o'clock?
Yes.
When you got home, do you remember about what time you got home that night?
1 o'clock?
How did you get home? Did somebody give you a ride?
Yes. A
So your-
coworker.
Did your mom didn't pick you up that night, did she?
No.
When you got home at 1 o'clock, did you go to your bedroom?
Yes.
Downstairs in the basement area, the lower level?
Yes, sir.
Did you see Timothy at all?
No.
Did you check on him at all?
No.
When did you next become aware that something was happening with Timothy?
The next morning.
And what happened?
I had to get up early so that Shanda could drive me to the premises area of work. And I'd gone to the laundry room to get a pair of clean socks and was then made aware that he was not breathing.
And where was he at that point in time?
In the closet.
And who made you aware that he wasn't breathing?
Shanda.
Was he on his bunk bed?
No.
Was he ever on his bunk bed from the time that he was in that small closet until the time the police arrived?
No, sir.
If you know, do you know how much time passed from the time that you first became aware he wasn't breathing until 911 was called?
18 minutes?
And during that 18 minutes, did you tell your mother or ask your mother if you were going to call 911?
Yes, sir.
Do you remember what she said?
No. She said no. Sorry, that was my bad.
I'm sorry, good. Let's clarify that. Do you remember what your mother said when you asked her if we should call 911?
She said no.
So you didn't call 911 at that time?
No.
During that time period, what were you doing?
I was attempting to resuscitate, though it was too late.
At the time when he came out of the small room, how did he get out of the small room at that point? How did his body actually come out of the small room?
He was removed.
By who?
Shanda, and I believe I helped a bit.
What was he wearing when he came out of the room?
Nothing but an adult diaper.
At some point, did you put clothes on him?
Yes.
Who put the clothes on him?
Both me and Shanda, per Shanda's request, order, however you'd like to phrase it.
So before he was wearing the diaper, but you put the clothes on him while he's unresponsive outside of the small room?
Yes.
And do you remember what clothes you put on him?
A hoodie, a pair of my jeans, and Shanda had me remove my belt and put it on him.
Did she tell you why she wanted you to take the belt off and put it on?
Because the pants were too big.
At some point, the 911 is actually called, is that correct?
Yes, sir.
Now, before 911 was called, and I guess let me ask you this, who actually called 911?
Me.
But did Shanda actually talk to the 911 folks, if you remember?
Not that I remember of, no.
Before 911 is called, was there some discussion about a hunger strike?
Yes.
What was the discussion about the hunger strike at that point?
Shanda said to say that he'd gone on a hunger strike.
When
And
said
that we
who was
found
she-
him on the bed.
Seems
dead.
obvious, but who was she referring to?
Timothy.
And said that he was found on the bed?
Yes, the bed.
So 911 comes at that point, and then the police are also involved, is that right?
Yes, sir.
At some point in time, did the police leave you guys alone in the home?
Yes.
Later that night?
Yes.
And when that happened, did Shanda do anything with any of the items in the house?
She disposed of evidence.
What did she dispose of?
Vibration detectors, a camera upstairs that was not confiscated. She broke the memory chip that was inside into 4 pieces and threw them out the window as we were driving to Grandma and Grandpa Vander Ark's.
So you went down to Grandma Vander Ark's that night?
Yes.
And she disposed of evidence on the way down to...
Yes, and the vibration alarms were thrown into a trash can, stuffed in a plastic bag and thrown into a trash can at the Chick-fil-A near our house.
When you say the vibration alarms, are you talking about the sensors that were on the doors?
Yes.
Was one of those the sensor that was on the small room door?
Yes.
Just a moment. Mr. Ferguson, we've had you testified about some of the alarms that were placed on Timothy's body. Did those alarms, what would those alarms do? I mean, how would they make noise or alert people?
A loud beeping.
Was that something you could hear if you were like, close to the alarms?
Yes, through solid wall even.
And did Timothy have some ear problems?
Yes,
What were-
sensitive hearing.
He had sensitive hearing?
And had tubes implanted at one point.
To your knowledge, was Shanda aware that he had these hearing problems and the tubes in his ears?
Very much so.
And again, to your knowledge, was it indicated to you that the alarms were a form of punishment for him, that as if they went off, they would be harmful to him, or
Painful.
distracting to him?
I believe so.
And we talked about being made to stand against the wall. Was he made to do something else against the wall as a form of punishment as well?
Wall sits.
And wall sits, for the jurors that might not be aware, is what, basically?
Back pressed against the wall, sitting with your, crouched with your legs as though you're sitting in a chair.
But nothing to support your weight on your buttocks or your upper thigh area?
No.
And at some point, he was forced to do that as well? I have no further questions.
You may be seated. Mr. Roberts, you can continue.
Thank you. Before we get back to the question I originally asked Ms. Vander Ark, you just obviously had quite a visual reaction there to the jury, a physical reaction in front of the jury looking at those photographs. That's not the first time you've seen these photographs, though, is it?
No, sir.
In fact, you sat in this very courtroom not even a week ago on Friday when we had a hearing about those photographs and looked at those photographs, didn't you?
I did not look at them last week, sir.
You didn't look at them last week?
No, sir, I did not.
But you've looked at them before, haven't you?
It was, I think it was at the prelim, and I gagged that day too. It just wasn't as bad.
Didn't throw up, though?
No, it wasn't as bad.
So if there's video from that hearing that we had last week where you thumbed through the photographs, including the autopsy photos, without vomiting, do you just not remember that as well?
We didn't have the
may be seated.
All right, we are back in the record in file 23110 FC, People versus Shanda Vander Ark. The court has been informed the jury has reached a verdict. Mr. Johnson, Ms. Vander Ark is not present. My understanding is you had an opportunity to speak with her and discuss her presence today. Is that correct?
That's correct, Your Honor. That's where I've been since our last adjournment. So I just came up with her. She's declined to join us for this portion of the trial.
Okay. During the break, I anticipated that, and I did a little case law research. There is no law in the state of Michigan at this time that requires the defendant to be present for the verdict. There is a law that does require her to be here for sentencing and hear the victim's statements, but so the court was essentially left with a choice of forcibly compelling her to be here, which could cause her to, I don't know, could cause further issues. We have deputies that certainly, if I order them to do that, they would do that, but I don't want to put them in a position of harm if something happens, and I don't think that's appropriate. So I'm not going to do that, and again, there is no law that requires her to do that. So, Mr. Roberts, anything for the record before we bring the jury out?
Your Honor, I would concur with the court's research here. I think that we're all aware that there was a law recently passed that requires the defendant to be present for at least the victim impact portion of sentencing, and I agree. I don't think there's anything that requires her to be here. So pursuant to the written stipulation that she has already filed and has been witnessed and updated by Mr. Johnson as we go here, I think we can proceed without her presence.
Okay. Anything else, Mr. Johnson, before we leave the jury?
No, sir.
All right, please rise. You may be seated. All right, ladies and gentlemen, the court has been informed that you have reached a verdict. If that is true, I'd have the foreman please rise and give the verdict form to Mr. Weaver, the bailiff. All right, thank you, Mr. Weaver. Can the foreperson please rise and announce the verdict?
She has to read the whole thing, or?
Typically, there's no set way to do it, but typically you could say in the people of the state of Michigan versus, and then on one count, what the verdict is, and count two.
And the people of the United States versus Shanda Vander Ark, count one.
I think you mean people of the state of Michigan, correct?
Oh, I'm sorry.
Yep.
I apologize.
Okay, all right, that's
The
okay.
people of the state of Michigan versus Shanda Vander Ark, count one, charging open murder involving the death of Timothy Ferguson. We find her guilty of first-degree felony murder. Count two, first-degree child abuse. We find her guilty of first-degree child abuse.
All right, thank you. Court will record the verdict for the record. Mr. Johnson, would you like the jury polled?
Please.
All right. All right, juror number 2, please rise. And is that your verdict?
Yes, sir.
Juror number 4, is that your verdict?
Yep.
Okay. And you don't have to say, you can say yes or no. So, juror number, actually that was juror number 4. Juror number 5, is that your verdict?
Yes.
All right, you can sit down. Juror number 6, please rise. Is that your verdict?
Yes, sir.
All right, juror number 7, is that your verdict?
Yes.
All right, juror number 8, is that your verdict?
Yes.
Juror number 9, is that your verdict?
Yes.
Juror number 10, is that your verdict?
Yes.
Juror number 11, is that your verdict?
Yes, Your Honor.
Juror number 12, is that your verdict?
Yes.
Juror number 13, is that your verdict?
Yes.
And juror number 14, is that your verdict?
Yes.
All right. So with that being said, again, the court will record the verdict for the record. Ladies and gentlemen, I thank you for your service. This was an incredibly difficult case. Now, you know, when the attorneys were discussing what the evidence would be, I think you understand what we were talking about. Unfortunately now, it was not for the faint of heart, and certainly those of you who did this, unfortunately, it's unfortunate that you will not get those images out of your mind. I won't. But somebody had to do it, and I'm glad that you were willing to do that. You are discharged of service at this time. You are free to talk to anyone you wish about this, or you don't have to talk to anybody if you don't want to, but you're free. The restriction regarding news reports, you can do anything you want. You can talk to anyone you want at this point going forward. So again, thank you for your service, and you are excused. Mr. Weaver, please rise. Anything else for the record, Mr. Robbins?
Yes, Your Honor, officially moved to revoke bond. I don't believe bond has been posted, and I don't know if it was set, but in light of the conviction, I think the court is required to revoke bond.
Okay, Mr. Johnson?
I don't know if you ever had bond, but
I don't know either, but certainly, given the nature of the crime, the court is going to revoke bond. We are going to schedule sentencing for January 29th, 2024 at 8:30 a.m. The court's going to refer the matter to state probation for preparation of a pre-sentence report. And again, bond is revoked at this time. Anything else for the record, Mr. Roberts?
No, thank you, Your Honor.
Mr. Johnson?
no, sir, thank you.
Gentlemen, I can't say enough. You were very professional. I think you did both did an incredibly good job, and certainly, again, professional, and I certainly appreciate that. We were very efficient, and I think that's important. So thank you very much, and have a good afternoon, have a good night, and have a good weekend. Thank you.
Thank you, Your Honor.
We're adjourned.